I declare open this public hearing of the Legal and Constitutional Affairs References Committee inquiry into offshore processing and resettlement arrangements. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and online. I am the chair of the committee, Senator Leah Blythe, and joining me today are Senators Cox, Senators Shoebridge and Senator Duniam. And Senator Stewart. Before we begin, I remind senators of their obligation under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such an action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. I now welcome representatives from the Law Council of Australia. Thank you very much for taking the time to come and speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses has been provided to you and is available from the Secretariat. For the Hansard record for this session, can I please get you to state your full name and the capacity in which you appear? I don't know who wants
Tanya Wolff.
Thank you.
I'll start. Thank you. Thank you, Chair. Tanya Wolff, President of the Law Council of Australia.
Karina Ford, Chair of the Migration Committee of the Law Council of Australia.
Yeah, Angelini, Principal Policy Lawyer, Human Rights at the Law Council of Australia.
Excellent. And do you have an opening statement you would like to give first?
Yes, Chair. Thank you.
Certainly. Proceed when you're ready.
Thank you. The Law Council of Australia welcomes the opportunity to appear before the committee this morning in relation to its inquiry into Australia's offshore processing and resettlement arrangements. We acknowledge the traditional owners and custodians of the lands where we are each joining from today, and we pay our respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples who are in attendance. The Law Council does not have a position on the financial matters relating to offshore processing, which are covered in subparagraphs A, Roman numeral 1 to 4 of the Terms of Reference. Instead, we wish to focus on the issue of potential refoulement of people to whom Australia owes protection obligations by countries, including Nauru, with which Australia has offshore processing and resettlement arrangements, and on the rights of non-citizens transferred through those arrangements. These matters fall within paragraph A, Roman numeral 5 of the Terms of Reference. Offshore processing must accord with Australia's international human rights and refugee law obligations. When arrangements are entered into between Australia and other countries for the purpose of processing protection claims and for the purpose of processing and providing resettlement, Australia remains responsible for ensuring that those obligations are adhered to under the arrangements. UN human rights treaty bodies have confirmed this to be the case, where, for example, Australia funds or jointly manages detention operations. The committee has before it comprehensive evidence of serious and irreversible harms caused by these arrangements. Despite significant public funds being spent on such arrangements, there is no clear evidence that such harm will not continue to be caused. In this inquiry, the Law Council is concerned about the risk of chain refoulement. Australia cannot send non-citizens indirectly to a place where there may be caused harm, including where Australia knows or reasonably suspects that they will be returned to their home country by a third country. The Law Council is concerned that Australia cannot credibly claim ignorance of this risk in relation to its arrangements with Nauru. The President of Nauru, in an interview read into Hansard, appears to take the view that people sent by Australia to Nauru are not refugees and will be returned to their own countries at some point in the future. This is precisely the kind of knowledge that engages Australia's non-refoulement obligations. We remain concerned that the Memorandum of Understanding between the Australian Government and the Republic of Nauru to facilitate the removal of the NZYQ cohort still does not appear to have been published. As stated in our submission, this compromises the transparency of these arrangements. The lack of transparency also extends to the potential number of persons who may be transferred from Australia, whether it will extend beyond the NZYQ cohort. And our submission calls for the publication of the Memorandum of Understanding, without which neither the Committee, Parliament, nor independent bodies can assess whether Australia's non-refoulement obligations are being met in practice. Thank you, Chair. That concludes our opening statement.
Thank you very much. We will now move to questions. Senator Shoebridge.
Thanks very much, Ms Wolfe, and to the team for your submission. The Commonwealth Government has raised PII claims to resist providing the MOU to either the Senate or the public. These are public immunity claims. When you have a look at the government's response to pretty much anything involving Nauru and PNG, I think I've got a list of at least a dozen similar public interest immunity claims that have been raised by the Commonwealth to prevent them providing documents about payments to Nauru, payments to PNG, the arrangements under which people are sent to Nauru and PNG. Has the Law Council had a look at that raft of public interest immunity claims made by the Commonwealth in relation to offshore processing?
Thank you, Senator Shoebridge, for the question. To my knowledge, I'm not aware of whether we've looked at the raft of claims at this point or raft of issues. If I could just invite my colleagues to deal with that question.
I'm happy to answer that question. We haven't looked at it in detail, but clearly we have concerns over the fact that the MOU has not been made available. And I've read the Department of Home Affairs submission, and it is a shame in some respects with regard to these Senate inquiries that the department doesn't appear first, or maybe is offered an opportunity to reply later, because I note that they are the last speaker for the day. These are continual issues with the transfers to Nauru, whether they be under the transitory persons or now this new cohort of people, because clearly the information is missing as to even, for example, can the visa be cancelled at some point if a crime is committed in Nauru? Is it always going to be 30 years? What is the situation if the government changes, etc.? So it's a shame that the document can't be made public, because I think it would give answers, given the amount of public spending that is being put into this situation.
Well, when we have billions and billions of dollars of public money being paid under an arrangement, it doesn't seem unreasonable that the public see the details of that arrangement, and in this case the MOU. Would you agree?
Yes, we would, and that's covered in our submission.
We have seen there's currently litigation on in PNG where the Australian government is being sought to be joined to an action brought by people who have sought asylum in PNG and have been the subject of Australian offshore processing. Are you aware of that legal action at all?
No,
I'm not aware of the specifics of that. Sorry, Senator Schubert.
Yeah. But, I mean, one of the issues that litigation brings forward is the repeated arguments from the Australian government that when they provide money and enter into arrangements with whether it's PNG or Nauru for the treatment of people who have been removed from Australia or captured by Border Force when they were seeking to come to Australia and then sent to PNG and Nauru, the Australian government repeatedly says, well, what happens in PNG and Nauru is not a matter for them. That if human rights are abused or people's health is abused, that it's a matter for PNG and Nauru and it's not a matter for the Australian government. Does the Law Council have a response to that repeated argument from the Australian government?
Well, I mean, it's clearly not true based on both our submissions and the international obligations owed, and also just the sheer amount of cases relating to people who have been transferred to Nauru. As you'd be aware, Senator, there has been many compensation cases paid out over the years due to the side effects of people being transferred to Nauru, and that's covered in many of the submissions before you of examples. But yeah, I mean, clearly the answer is that Australia does have an obligation, which is why, again, the MOU is important to be seen.
Yeah, I mean, what would be the kinds of things you'd be looking for that either are or aren't in the MOU to give an indication that Australia understood what its international obligations were if it sends anyone to Nauru? And, you know, what are the things you'd be looking for in the MOU?
Senator Schubert, I would expect at least a specificity as to who it pertains to, because there are considerable concerns about a creep and that it will have an extensive and expansive application, which I think has been touched on by submissions that the committee has received from other bodies. But beyond that, I think that there would be some assurances about those international obligations which Australia owes to those that it will transfer to other, to the third countries that are going to be ultimately responsible to make sure that we're not putting these individuals into harm's way in the way that is certainly apparent. But I can invite some of my other colleagues to talk to that in more detail.
Ms Ford?
I was just saying,
Yep. Go.
Chiara, did you want to add anything there?
Yes, I would add, I mean, at a minimum, that we would want to see guarantees, as is recommended in our submission, of compliance with international obligations, as well as independent monitoring and oversight in respect of the arrangements to ensure that human rights obligations are being upheld in the circumstances.
Well, we've seen the translation of President Adiang's statement that he made after the MOU was entered into. Now, for some reason, known only to Minister Burke and Home Affairs, the government is refusing to provide their own translation of the statements of President Adiang and are hiding behind the excuse that the translation that's been provided by third parties is not some official translation, but it's the clearest evidence we have about what President Adiang has said. And that statement includes that that Nauru's intention is to take people only for the time being, to return these people home, and no indication of any sort of security that people who have been sent from Australia to Nauru would have on Nauru. Can you talk through whether or not how those statements fit with Australia's obligations to not engage in refoulement?
I'm happy to speak on that. Yes, I mean, they clearly don't fit because particularly the cohort that the President was talking about is the NZYQ cohort, who majority of them, if not nearly all, have been found to be refugees and can't be removed to their home country. So the statement's inaccurate in that respect, in that whether or not they have committed a crime does not mean that there are not international obligations owed. And that is where in the MOU it needs to outline specifically how those people will be treated.
Yeah. And the refusal of the Australian government to publish the MOU it raises concerns for me that these protections are not contained in the MOU because they've got a dealing with Nauru. How do you read the government's refusal to provide a copy of the MOU to the Australian public? And if there were elements of it that might be commercial or otherwise, they could even provide a redacted version, but their refusal even to provide a redacted version of the MOU. What's the Law Council's view about that?
Senator Sheepridge, we can't talk to why the government hasn't provided that MOU as requested. We certainly ask that the government does. And can I just add, though, that the interview that was read into Hansard is, in our view, that the underlying position in relation to that is factually wrong, because we know that approximately 83% of the cohort are owed protection obligations under our own Migration Act, and we are concerned that a leader operating under that misapprehension may order returns without a refugee status assessment, and that's the definition of chain of refoulement, which is underlying our submission and enhanced in our position, our submission.
Those concerns are very real because President Adiang said about the NZYQ cohort, the great majority of which have been found to be refugees, he said, to clarify, these people are not refugees. That's the position that came from President Adiang. And it's hard to describe that as anything other than blatantly either ignorant or intentionally wrong. But that statement to clarify these people are not refugees from President Adiang, that's plainly untrue, isn't it?
Correct, yes, it's plainly untrue.
And if Nauru is treating this cohort as though they're not refugees, well, that raises the very real concern of chain refoulement, that they'll be sent back to be persecuted from the countries from which they fled. Is that right?
Yes, correct.
Yeah. So we have a vacuum of information from the Australian government, the refusal to provide the documentation under which these people are returned, and then within that vacuum, we have these very disturbing statements from the President of Nauru that raises the real prospect of significant human rights breaches. That's the state of play, isn't it?
It appears to be so.
Yeah. And it would be within the power of the Australian government, Minister Burke, to set matters straight by the simple function of publishing the MOU so we could see for ourselves.
Yes, correct. I mean, the whole, as you'd be aware, Senator, there were a number of bills passed with not much parliamentary scrutiny, which we have covered in our submission, that lead up to the MOU. It's the Law Council's position that there should be open and transparent scrutiny of bills, and that given the MOU has such an impact on human consequences, that it should be made available to ensure that international obligations are met, and that also we are not putting another generation of people through the harm that we have done previously over the last 10 to 12 years. And I talk of that both as my position as chair, but also as a legal practitioner that has dealt with Nauru transfers and Manus Island transfers for many years. And in my experience, they have experienced such hardship and ruined many lives through that process. So this is why a transparent MOU is vital to ensure that we have adequate health, medical care, opportunities for employment, enjoyment of life, freedom of from harm, etc.
Fantastic, thank you. Senator Duniam.
Thanks. I've only got a couple of questions, but just following on from Senator Shoebridge's question just now, the the claim that the misapprehension that the Nauruan government appear to be operating under, based on the points you've put forward, is it the Law Council's contention that the misapprehension the Nauruan government or its representatives are operating under is as a result of being misled by the Australian government?
No, that's not our position, Senator. It just appears on the face of it from the interview that was read into Hansard that there is a mistaken apprehension, but we make no comment beyond that. So they are misunderstanding of these people's rights or obligations owed to them by Australia, but we don't know where they've become they've come into possession of the information around the cohort that they're accepting. Yes, Senator, we can't. What is clear from the interview, at least in relation to the interview that was read into Hansard, is that the President believes that the people sent under the NZYQ arrangements are not refugees and can eventually be returned to their home country. And that belief is factually wrong, and that's what we have stated in our submission.
Has the Law Council... Sorry, Ms Wolfe, go on. Sorry, go on.
No, all I was going to add was that where that misapprehension stems from is not something that we can really comment on.
Has the Law Council sought clarification from the Australian government about the fact that Australia has entered into an MOU with another sovereign government and the co-signatory, Nauru, is operating under this misapprehension? Has it been raised with the Australian government by the Law Council?
To my knowledge, this has not been something that we've specifically raised, but certainly our submission talks about a number of concerns that we have, both with the treatment, the conditions, and the fact of that removal to Nauru in those circumstances.
And you mentioned before the number 83% of the cohort in the Law Council's views are owed certain obligations by this country. Have you raised that with the Australian government directly? Not through this committee, but the correspondence with the relevant minister?
To my knowledge, that has not been a specific issue that we have raised, but can I just check with my colleagues?
Yes, I can confirm that we meet regularly with the Department of Home Affairs through the Migration Committee, and this has been on, to be honest, transfers from Nauru, transitory people, removal to Nauru has been on our agenda on majority of meetings, so yes.
Okay, so you have raised the issue, maybe not the number or the specific elements that have been expressed here in the submission. Can I ask them what response is given in those meetings, Ms Ford, if they're raised at regular meetings around this contention that some of those who are, I presume the point made here, that some owed certain obligations are not being afforded them. Does the department have a retort to that or a response to the view put forward by the council?
Given those meetings, it's not appropriate to discuss the contents of those meetings, other than to say what we have put forward is not just in this submission, but it's in the submissions relating to the bills that were passed last year on this issue. And I understand the Department of Home Affairs responded also to those bills. In fact, I think they were the only party to appear in the bill that was passed in August last year.
Okay. Well, I'm just following on from this theme about lack of transparency. I'd just be concerned that another discussion relating to home affairs and this government is not appropriate to disclose. We're talking about third parties here and individuals. I can ask the department later on today, or my colleague can.
You can ask the department. Look, we bring up issues that affect applicants and persons that are affected by legislation, and we advocate for change in this space. But, you know, in terms of a department response, obviously the department will generally be guided by what the government intends to follow through with. So, I mean, there's not much more I can add to that in terms of it. And clearly it hasn't led to change, so the position's pretty clear on both the department and the government's side.
And Senator, if I may add that, you know, our concerns are made very clearly about this and have been expressed clearly, but these matters certainly could be raised directly with the department.
Indeed, and I'm sure we'll do that. So just in general, the concept of third-party processing arrangements, are they intrinsically unworkable, or are there changes that could be made that would make such a proposition workable, or is it just a non-starter?
I guess fundamentally we have a position in relation to this, that we don't take a position on border management policy as such.
Sure.
That's really a political question. What we do say is that, you know, the High Court has upheld the constitutional validity of domestic provisions supporting offshore processing, but that only answers the question of whether it's legally permitted under our domestic law. It doesn't answer whether it's the most effective deterrent or whether it represents the best use of over $13 billion of public money, or whether it's the right response morally or ethically for people particularly who are fleeing persecution. Those are legitimate questions for this committee and for Parliament, of course, but our role is narrower, and our role today has been narrower, to say that however Australia chooses to manage its borders, it really must do so within its international obligations. And perhaps my other colleagues might have more to say in relation to that.
And just as before I think Ms Angeloni was about to speak, sorry to cut you off, just on that, I mean, I'm not asking for an opinion, I'm not asking whether you think there are better models. The one the government have made a decision to pursue, and it's one that previous governments have chosen to pursue, is the one we're talking about here. And my question was, and it does go to the point you've raised, about the legality, I suppose, the Law Council of Australia, experts in that field, is it in any way workable with changes made, or is it a non-starter? It's broken and should not be pursued, is the fundamental question I'm asking. And whether you, Ms Wolfe or Ms Angeloni wants to speak to that, it's up to you.
Senator, I was just going to add that at a minimum we would want to see guarantees in terms of protections of human rights obligations in the MOU, and the lack of transparency undermines our ability to make that assessment. But there is also significant evidence before this committee about the conditions of offshore processing in Nauru and other countries with which Australia has entered these agreements, and that needs to be considered as well as part of a human rights assessment of the workability of these arrangements.
Yeah, I mean, the historical context is important because it hasn't worked in the past, and it's unclear without seeing the MOU how it's going to work, no matter how much money you're going to spend at it.
Okay. In terms of, look, I'm actually fine with that. Thank you very much. Thank you, Chair.
Thank you. Senator Cox.
Thank you, Chair, and thank you for appearing today before the committee. I just wanted to drill down a little bit into your submission that you made, and Senator Shubridge and Senator Dunniam have done a pretty good job in sort of getting you to flesh out some of the concerns that you have around regional processing arrangements, particularly in Nauru. And I just wanted to clarify one point, that in your submission, you said you don't want to make any submissions on the financial matters relating to offshore processing. Is there a reason for that?
If I may jump in there, Senator, thank you for your question. It was primarily going to the focus we were bringing through the Law Council's perspective to the inquiry, being it's the consistency of these arrangements with Australia's international human rights and refugee law obligations.
Yeah, but I think the quote just made, I'm sorry, I can't see your names online because they don't have them against your frame. But, you know, the off-the-cuff comment about the money that's being spent on regional offshore processing goes to the heart of, like, you now are making commentary around the financial arrangements that Australia has with Nauru. So I know that your focus of your submission wasn't, but then you've sort of gone there now. And so I'm just wondering why that is and that there are no further submissions on that.
Senator Cox, we've obviously had the benefit of reading both the Department of Home Affairs report as well as, well, I think there were many submissions done, but we've read probably 20 or 30 submissions that were put forward. And clearly it outlines the significant amount of money that is being invested in Nauru. So I feel that we have more knowledge than when we had the paper. In terms of putting a further paper forward, I mean, submissions closed at a certain date. So, but yeah, we have had the
Anything
benefit
that, sorry to cut you off. Yeah, sorry to cut you off. I'm just, you know, there would be opportunity for you to table a document if it's something you wanted to take on notice, and would be happy to provide a further submission that the committee could accept. I think, given that you know, particularly the Law Council's expertise is in the legal frame, I think Senator Dunniam just referred to that. Also, there's been a lot of conversation. I think there was a quote just a minute ago in relation to a guarantee around Australia meeting its international obligations. One, you know, can you give us an example where Australia hasn't met their international obligations in relation to its regional offshore processing at Nauru?
Senator, the most significant evidence comes from the Nauruan president himself, really. His interview read into Hansard indicates he believes that people sent under the NZYQ arrangements are not refugees, as I've mentioned, and they're going to be eventually returned home. That is wrong. Factually, as we've mentioned, there are approximately 83% of that cohort who are owed protection obligations under our Migration Act. And when a leader is operating under that mistaken belief or misapprehension, that may lead that leader to order returns without any refugee status assessment. And that's the definition of chain refoulement, which is what we've mentioned beforehand. And the REP submission and the AHRC submissions before this committee also document serious concerns about healthcare and targeted violence and conditions on the island, and you might be able to ask them in more detail when they're making their submissions.
You know, there are times in this committee when we accept that there are political motivations for making commentary about, you know, the Australian government or ministers, in fact, and they've done a pretty good job at that today, a real hatchet job against our Minister for Home Affairs. The translation from the President, and anybody that knows anything about language translation knows that some things are not directly translatable in English. So there are commentary that is made in different languages, particularly Indigenous languages, and as a First Nations person, I know that firsthand. So there is not a word, for example, for the word bail. So, you know, in Indigenous languages. So we find it pretty hard to explain terms and explain circumstances and situations to Westerners or English speakers if they just pick up a transcript and say, well, that's the translation and that's what we understood, and then proceed to, without any evidence, make an assumption that that's what the President of Nauru's stance is, I think, has a lot of holes in it, to be honest, because there is no direct translation from my understanding. There was a translation provided on what he said, but again, no confirmation of what the President is understanding by that. And again, if Minister Burke, as the Minister for Home Affairs or the Australian Government, have not provided the MOU in public. We can sit here all day and have a conversation about redacted documents and how senators in this committee in particular will wave around documents and estimates and say, what's the point of providing a document when it's this much redacted? Well, it is commercial in confidence. And I'm sure you understand that from a legal point of view. Yes. So I'm really keen to understand, now that we've got legislation in which the government passed, as you said, in August last year, what does that look like now in relation to your position that you're presenting to the committee, putting aside what I've just explained around the translation? Does that alter your position in relation to, we don't know, we will wait and we will continue to pursue some of that information, or are there other things that you would like us to know?
Quick
Senator
responses,
Cox.
if I could. Sorry, firstly, the evidence is now extensive. It comes from the UN treaty bodies themselves, not just advocacy groups. The UN Human Rights Committee has actually found in October in 2024 that Australia arbitrarily detained asylum seekers transferred to Nauru in breach of the ICCPR, and also the Committee Against Torture found in November that last year that Australia was responsible for torture and for the ill treatment at Manus Island, despite physical acts occurring in the PNG at the time. So these are binding views. They're addressed directly to Australia, and the committee has that material before it in various submissions in relation to the 2025 legislation. We do have significant concerns about that. It stripped procedural fairness rights from the removal process. People can be deported without a meaningful opportunity to present their case, even where removal options haven't been exhausted. The AHRC submission, which you have as well, confirmed that there were, I think, 2 of the first 3 people targeted hadn't even completed their appeal avenues. So there's a fair bit of information that is there. It's not a process that gives us any confidence that Australia's non-refoulement obligations are being properly assessed before this occurs. And I may have come in over the top of Ms Ford, and I apologise for that, but I expect she might want to add to that.
Yeah, and I guess,
And just for noting, that was under the previous government, right? Like the cases that you've just announced were under the previous government, not under our government.
I understand that the factual basis of the factual scenarios were in the past, the decisions have been made in the last couple of years.
Thank you.
And I mean, it is reflected in past experience by the fact that there remains 804 transitory persons with still no permanent status, and they were transferred due to a lack of medical care being able to be met in Nauru. And there is nothing that is before Parliament currently as to how that is going to be improved if and when more people arrive. And that's also what is lacking. There is a lack of numbers. We just don't know how many people may end up being transferred to Nauru, and clearly the more that get transferred, the more impact it has on health services. And you're talking also about a cohort that has a significant amount of mental health issues as well, and how they're going to be dealt with.
Okay. Just out of interest, were there any concerns in relation to any other folks that were on Nauru that are not refugees or found to be refugees?
I can't talk directly to that. I'm not sure if my colleagues have something to say.
Yeah, I'm not certain as to what you mean by that, Senator. Or whether you're talking about people who may be or are already there. I'm not certain about that.
Well, I think it goes back to the question, the original, this is the statement by the President. Like, I think the framing of whether they're refugees and, they're going to be treated as refugees and under the refoulement obligations that Australia have. Are there any other concerns around other people who have, or who are already at Nauru? I think you've answered some of that in relation to the UN treaty bodies issue, but I just wanted to see if there were any other concerns that have been raised directly with you more domestically in relation to that.
I mean, there's clear concerns about persons who may be transferred to Nauru who are found not to meet the Refugee Convention or complementary protection, and one of the key factors of one of the bills passed was the ability to reverse protection findings. So those persons may also be transferred to Nauru, which is going to put more pressure on Nauru on how they're going to be able to cater for all these extra people. I mean, again, this all comes down to the more people that are transferred there, is Nauru capable of being able to provide a quality of life that meets our international obligations? And it hasn't previously been, nor did it work with Manus Island. So these are the issues that need to be put to the department today, and which is why clearly the Papua New Guinean President's comments were concerning, even if there was an interpretation issue. But I do wish to indicate that we, in migration law, we use interpreters all the time. Yes, it's not 100% perfect, but it does still often represent what may be put. And if there are concerns, maybe they are comments that the government or this committee could put to the Nauru President to check and see whether or not they are his views.
Senator, if I could please add as well, regardless of refugee status, obligations under treaties like the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights are owed and will be relevant with respect to conditions faced by non-citizens transferred under these arrangements. So that goes for things like healthcare, adequate standard of living, family unification, and so those also need to be considered in terms of what these arrangements look like practically.
Sorry, I was on mute. I don't have any more. Oh, did you just want to add something, Ms. Wolf? Sorry.
No, I was just going to tell you.
Sorry,
you
I just didn't hear you. I was on mute. Thank you. I don't have any more questions. Thanks, Chair.
Thank you very much, Senator Cox, and thank you all for appearing and giving evidence to the committee today. We are very grateful. So we are happy if you've had questions to be given answers on notice. If you could do that by the 18th of May, we would be very grateful. And with that, you are released, and the committee will now suspend until 11:45.
Thank you.
Thank you, Chair.
I now welcome representatives from the Refugee Council of Australia, Asylum Seeker Resource Centre, Human Rights Law Centre and Visa Cancellations Working Group. Thank you all for coming in and taking the time to give evidence to the committee today. I understand that information on parliamentary privilege and the protection of witnesses has been provided to you and is available from the Secretariat. For the Hansard record, can I get you each to state your full name and the capacity in which you appear? So we might start with you, Ms Dixon, and we'll work our way along.
Hannah Dickinson, the Chair of the Visa Cancellations Working Group.
Dr Graham Thom, Advocacy Coordinator for the Refugee Council of Australia.
Laura John, Associate Legal Director at the Human Rights Law Centre.
Jana Favero, Deputy CEO, the Asylum Seeker Resource Centre.
Excellent. And sorry, who do we have online?
It's Mariam, as asylum seeker and refugee.
Fantastic. Thank you very much for that. Do you have opening statements that you would like to give before we commence? Yes?
Yes, we do.
Yeah.
Yes, please commence when you're ready. Now, I understand that Asylum Seeker Resource Centre is going to go first.
Yes.
Excellent.
Thank you. I'll start and then I'll go to Mariam, who's online. Thank you very much for having us appear at this inquiry. I'd like to acknowledge that we are on Ngunnawal country and that sovereignty has never been ceded. I'm giving evidence on behalf of the Asylum Seeker Resource Centre. We have experience working directly with people who have been subjected to offshore processing and offshore detention over the past 14 years. Our detention rights advocacy program is a team of qualified social workers who provide over-the-phone psychosocial support to people who have been in offshore detention. We are here to represent and be the voice of 700 people who are still in our community in Australia who were subjected to offshore detention, to the 26 men and their families who are still in PNG 14 years later, and the over 100 people who are currently detained on Nauru. Our social workers at the moment are in contact with 90 people who are on Nauru. We made our submission and supported the submission of 13 people with lived experience of offshore detention, many of them who are still currently experiencing offshore detention. The conditions that we've heard and our clients and people who we're working with directly tell us has been consistent over the last 14 years, and that is a strong message of harm and suffering at the hands of successive Australian governments that continues today. We recently did a health audit into the conditions of people on Nauru, and of the 90 people who we're currently working with, 95% are experiencing mental health conditions, 93% are experiencing physical health conditions. They discuss the lack of appropriate medical care, noting that IHMS has been providing medical support on Nauru for successive years. They talk about medical neglect. People don't have enough food to eat. There's a lack of food security. The issues and the harm and suffering are ongoing. There are also issues. We try and link people to adequate healthcare, but telehealth services are actually now illegal on Nauru, so we can't even link people to doctors to get remote support. Our audit also showed that people are really, really scared and not knowing what is happening to them in their future, as evidence in our statements and the submissions. People were told they were going there for a couple of months and they now have been on Nauru for over 2 years. There are a huge amount of communication issues, even getting in contact with people on Nauru. We often go days without people being able to contact us, especially when they've got dire health conditions. So I'm painting a very bleak picture, but that is the reality of the continued offshore detention to this day. I would now like to hand over to Mariam to provide her opening statement. Thank you.
I'm Mariam. I came to Australia by boat in 2013, just 2 days after 19th of July. After about 2 months around the Christmas Island, we were transferred to Nauru. The day we arrived in Nauru, what we saw completely was different from what the officers had told us in Christmas Island. It showed that they had lied to us. to just convince us to go without any resisting, without any making problem. Naro was the hell, exactly the hell. The temperature was over 45 degrees Celsius. The tents were very small. There was no space to properly walk or sit, move around inside. Each tent had 2 foldable beds with inflatable mattress. The ground was rough, covered with dust and rocks. We were only allowed to have shower 2 minutes, and after that, the water would be cut off. Many times we were still covered with shampoo and soap when they stop water. You could hear as children. Every day you could hear children were crying and women are shouting about this issue. The toilet showers were extremely dirty. So we didn't have any clothes for 6 months. So we had to use the same bra and underwear over the time. And being shower and being dirty, having shower and toilet dirty, we didn't have proper clothes. It spread the illness, especially gynecology women problem. And the most of the women suffered from the gynecological infection, including myself. The food was very poor. Most of the time we were hungry. Kids was hungry, crying and asking for the simple food, same as eggs, simple yogurt, everything like this. A lot of us lost weight. Myself, I went down to 40 kilograms at that time. The medical situation was very limited. We didn't have medications. We didn't have women's health issue was ignored because there was not even a single ultrasound, or we couldn't see gynecologists available, or for any antibiotic we had to wait at least 2 weeks. Mental health was another issue. It was serious issue. Our mental health got worse day by day. We could trust the counselor because when we complained, they would say, if you are not happy, you can go back to your country. And the only response was the giving medication to make us sleepy or feel foggy, to not think clearly. I personally, after 13 years, I'm still taking antidepressant tablets, and without it, my life is practically impossible. For immigration perspective, Nauru was safe because it was the island. We couldn't escape. It was very small island, so whenever we went, it ended up to the sea. But in reality, it wasn't safe at all. There was almost no real security, especially for women and kids. Some guards who were supposed to protect us were not suitable to be around the kids and women. I personally spoke to one of them who had been in the wars in Iraq and Afghanistan over times and was injured several times, and he wasn't in a normal mental health. He told me that he couldn't sleep. He would sleep only 45 minutes during 24 hours with medication, sleeping medication. Without medication, he couldn't walk, sleep, anything. And noises makes him crazy. So it was like they see us as an enemy. They were because immigration couldn't or didn't want to provide basic needs. We gradually start trading with officers, Australian, Norwegian, but all of them, they were working under the same Australian contract or company. At the first, officers would bring small things, same as tongues, lollies, chewing gums, and in return, we gave them small items like shampoo, cans, Tim Tam, headphones, which we received from the canteen. Over the time, the trading became bigger. Many people were smoking, but smoking was banned. So a cigarette became part of exchange and increased in value. Security guards was asking for, what can I say? For asking for sexual favor in exchange for cigarette, and asking for a kiss or hug from the children for lollipop or chewing gum. It's something was wrong that wasn't right, because, for example, lollies and chewing gums very often given selectively, especially the most of the time, some only for girls, small girls, not boys. Male officers would provide items to women, and female officers would provide items to men, which raised concern about those exchange or nature of trading. The first thing officer would ask, "Are you married?" It was something that made me suspicious. At the time, it was hard to concentrate, but on everything around us. But when I look back on it, I think the women and children were being groomed by security guard. They were using their power for their own gratification. So how could the officer protect us? And protect us from what? We needed someone to protect us from the guards themselves. People in Australia are paying tax, and that tax is being used in Nauru against us, to punish us, to harm us, and mistreat and harm us. And now I'm a taxpayer. It's funny, but now I'm a taxpayer. I'm on a bridging visa and I pay tax, and the government using those tax to harm people like me. And I don't want to continue this. It's not fair. You are just using the tax we pay to harm people, same as me. Other kids, they are just human. They're just innocent human. We are asylum seeker. We came here for safety, not for doing something wrong or doing things. Even now, after 14 years, I'm still dealing with mental health issue, physical problems, and the government doesn't want to accept that the policy has not worked. This law has only been used as a form of punishment against us. I know you have the power to stop it, to stop this cruelty, and hopefully you stop it. After 14 years, we are now devastated, and we felt dead and forgotten. And we think it's more than enough.
Excellent. Thank you very much. The Refugee Council of Australia.
Thank you, and I would also like to acknowledge we're meeting on Ngunnawal land, unceded Aboriginal land. The Refugee Council is the national peak body for people from refugee and asylum seeker backgrounds. Again, we'd like to thank the committee for allowing us to give evidence at this inquiry. Our submission made 8 recommendations. I think through those recommendations it is clear that the harm and suffering, not to mention the legal and financial consequences, demonstrate why this policy is unsustainable. Through our recommendations, we would also like to reiterate the need for independent oversight of anything that's happening offshore. The fact that the Human Rights Commission, the Ombudsman and even UNHCR cannot access what is in effect billions of Australian taxpayer dollars being caused to harm individuals is something we find incredibly disturbing. Just to keep my opening statement short, I guess the 2 other things that I would like to reiterate, look at the submission from the Department of Home Affairs. I know you're hearing from them later today. We find their characterisation of the resettlement options for people who have been taken offshore absolutely nonsensical. And even in their own submission, if you get to page 6 and 7, it is very clear that there is no longer any resettlement alternatives, whether it be the US, New Zealand or Canada. The people who are taken offshore, as well as the transitory people who have been brought back to Australia, are now trapped in a limbo, an ongoing limbo. And this needs to be made perfectly clear to the committee members who are undertaking this inquiry. Secondly, we're very concerned around the characterisation that the department has made of the Richardson Review. Let's be very clear, the Richardson Review was absolutely scathing. To say anything else is a total misrepresentation of that review. At the heart of that review, we believe, is the fact that if you are going to do deals in this environment with these sorts of governments, then the number of issues that this committee is here to look at are a logical consequence of doing deals with these governments. The physical environment on Nauru, the fact that it's 10,000 people on a territory the size of Melbourne Airport, of which 80% is uninhabitable, of which all the land is privately owned and therefore any land must be leased, opens up all sorts of issues for anybody who wants to do deals with that government. So I will leave it there and hand over to my colleagues.
Thank you. So Human Rights Law Centre.
The Human Rights Law Centre thanks the committee for the opportunity to provide evidence today. We acknowledge the traditional owners, the Ngunnawal people, and pay our respects to elders past and present. The Australian government's policy of offshore processing has caused irreparable harm to thousands of people and their families. Despite the scope of this inquiry, that harm cannot be artificially contained to the last 4 years. It is harm that has been inflicted since the reintroduction of mandatory offshore processing in 2012. It is harm that continues for the 100 or so people currently trapped offshore in Nauru, the 26 people abandoned by the Australian government in Papua New Guinea, and for the roughly 700 people living in our communities in Australia who have survived offshore processing but remain in visa limbo with no pathway to permanent residency. And it is harm that is already well documented. 12 years ago, this Senate committee found that the Australian government had failed in its duty to protect people on Manus Island. 11 years ago, the government's own commissioned Moss Review uncovered numerous incidents of sexual abuse and exploitation of women held in Nauru. 10 years ago, The Guardian released the Nauru Files with over 2,000 incident reports revealing the scale of abuse offshore. 9 years ago, this Senate committee concluded that harsh living conditions and uncertainty contributed to the widespread reports of abuse, self-harm and neglect in Nauru and Manus Island. 8 years ago, Médecins Sans Frontières, the only independent mental health provider in Nauru at the time, published a report showing extreme levels of mental health suffering on the island. 7 years ago, in response to the unfolding humanitarian crisis, the Australian Parliament passed the Medivac laws, providing a life-saving pathway for people left offshore to be medically evacuated to Australia. Just last year, the United Nations Human Rights Committee concluded in 2 decisions that Australia remained responsible for the harms caused by the arbitrary detention of asylum seekers in Nauru. It is precisely this history of abuse, mistreatment and secrecy that has created the conditions for systemic corruption to thrive in the Australian government's offshore arrangements with Nauru. That corruption should be properly investigated. However, it is the human impact of these policies that must drive long overdue change. Our client, Masa Mazaheri, now a mother and small business owner who fled Iran and spent 10 months in offshore detention in Nauru, asked us to share this message with the committee. I was 21 years old when my mother and I came to Australia in search of safety. Instead, we were sent to Nauru, where I never felt safe. When we came back to Australia for medical treatment, I met my husband. He came here just a few weeks after I did, but he was not sent to Nauru and was eventually allowed to apply for a permanent visa. We have 2 daughters who are 3 and 5 years old. Last week, I stood in the crowd and watched my husband and children receive their Australian citizenship. As a mother, I felt happy and relieved that my daughters are finally secure in the only place they have ever called home. After the ceremony, my oldest daughter asked me if we could now go on a holiday overseas to meet her aunties and uncles and cousins. How do I explain to her that if I leave Australia, I won't be able to return? How do I explain that after 13 years, I still don't have permanent safety? I'm now in my 30s. I will never get back the years I have lost to offshore processing, but I want the chance to have a safe future with my husband and my children. There are no procedural safeguards or any regulatory oversight that can reform a fundamentally flawed regime. There should be no doubt. Offshore processing is a failed policy which has cost far more in human suffering than can be measured by the $13.35 billion wasted on it. Given the corruption, neglect and irreparable harm that has already been exposed through 13 years of offshore processing, these same inevitable costs of Australia's new third country reception arrangements with Nauru must be seen as a deliberate feature of its design. The proposed deportation of hundreds of people in our community under these new arrangements to a place where they face a daily risk of violence, harassment, deteriorating health and hunger is reckless and unjustifiable. The offshore processing regime must be dismantled in its entirety, and every person subjected to it must be guaranteed safety and a chance to rebuild their lives. Thank you.
Thank you very much. So we'll now go to the Visa Cancellations Working Group.
Thank you. And on behalf of the Visa Cancellations Working Group, which is an expert coalition of more than 90 lawyers, civil society organisations and academics across Australia, I thank the committee for inviting us to give evidence. Our members work directly with scores of people at risk of forcible removal to Nauru and their families. We also acknowledge the Ngunnawal people and that we meet on the lands of the Ngunnawal people, traditional owners of this land, and the land is unceded. The third country reception arrangements this committee is examining represent a clear escalation of the offshore policies my colleagues have spoken about. They are accelerations in 2 critical ways. First, they expose people to forcible, effectively permanent exile to a country they have no connection with and where they may face serious harm. Previous arrangements were framed as temporary, and third country resettlement has historically been voluntary. This is permanent and coercive. Second, these laws do not intercept people at the border for ostensible deterrence. They extract often extremely vulnerable people from their existing homes and families in Australia and subject them to uncertain, punitive removal practices. Exile of this kind is grave punishment. Historically, it's among the harshest penalties short of death. Here, it is being utilised to avoid meaningful judicial oversight, substituting what has been found to be an unconstitutional extreme, indefinite detention, with another extreme imposed by the executive and without judicial oversight. The current targets of this new policy are the so-called NZYQ cohort, People in Australia who cannot be sent to their countries of birth and whose detention was found to be unconstitutional in 2024 by the High Court of Australia. This group are not distinguishable from anyone else in the community except by the accident of their birth. The majority previously held lawful visas, including permanent residency over years, sometimes since childhood. Many were entitled to citizenship years ago, and Australia is their home. At least 131 have Australian citizen children. Many more have partners, parents, deep community ties. At least 83% are recognised refugees. For this group, exile to Nauru means permanent family separation. Many of this group were subjected to unlawful detention for years and describe profound and lasting trauma and despair. Almost all live with chronic health conditions exacerbated by that detention, and some require ongoing specialist care and support, including for acquired brain injuries, severe cardiac or pulmonary disease, or life-threatening neurological diseases. One man told us, "I am paraplegic. I could die on the trip to Nauru or once I am there. It is difficult for me to know how to go on with life. I wake up in fear every day." This matters because medical care on Nauru has been shown time and time again to be critically inadequate. Hospitals provide basic medical care only. Specialist care is extremely limited, and the only option for people with serious illness is flight to Australia. For those who have committed offences, they have served their sentences, often years ago, and courts and tribunals have repeatedly accepted their sustained rehabilitation in many cases. But where another person would be free to resume their life, this group is punished again and again through redetention, unconstitutional visa conditions, and now the threat of forcible exile to Nauru based solely on visa status. Critically, no evidence whatsoever has been presented that this cohort presents any specific or heightened risk to the community. None have been found to warrant community safety orders. That's the scheme designed to manage unacceptable risk, designed specifically for this group. If even supervision conditions are not legally justified, permanent exile cannot be proportionate or risk responsive. But it is not just this misrepresented cohort at risk. Exile to Nauru is available to remove all non-citizens who have no right to remain in Australia and cannot be removed to their country of origin. That framework is breathtakingly broad. Even if the NZYQ cohort is prioritised now, the legislation permits removal of many others, including people on bridging visas and with ongoing legal processes at tribunals and courts. The avoidance of oversight and clarity, however, goes even further. The process for removal to Nauru explicitly and concertedly deprives people of procedural fairness. They may not be told the case against them or given any chance to respond and provide critically relevant information. The working group's clients receive no adequate consideration of health, family unity, rehabilitation, or the harms they might face. There are no published criteria for who is targeted. There is no merits review. There is no proportionality analysis. In our practice, our casework shows outcome of profound concern. People with severe disabilities facing removal, people with more than a decade of unblemished history, parents violently taken from children without notice, livelihoods, children's medical care and housing placed in jeopardy. It has also been repeatedly confirmed by Australian courts that this group faces unlawful decision-making in many instances in the past. This means that for individuals, but for a serious mistake of the system, they would not be facing removal and they would be continuing their lives in the community that they had established over years. As an example, a person targeted for removal for Nauru and detained without notice is able, despite low sector capacity, to find legal assistance. The lawyers identify that there is an unlawful decision, but the government refuses to pause removal so that a court hearing and injunction is required. The court agrees legal error is established and the man demonstrates to the tribunal that his visa should not be cancelled, but after prolonged detention where his health deteriorated seriously. This is a person who never should have been targeted and could now be in Nauru with grave consequences for him and his family. So there is no practical opportunity to correct errors before detention and removal steps, and people are routinely deprived of access. This is not an outlier, but because the system itself is broken. Many decisions are being overturned for illegality, which is symptomatic of flaws in the system. There is then the question of exile specifically to Nauru. My colleagues have spoken in depth, and submissions before the committee provide alarming details. The department suggests written arrangements with Nauru provide sufficient comfort, but over a decade of evidence says otherwise. The UNHCR has assessed that Nauru lacks the capacity to assume long-term responsibility for removed persons. NGOs like Médecins Sans Frontières and Save the Children have been expelled, and although media are routinely denied entry, abuses, corruption and deaths are well documented. This group has also been the subject of inflammatory media comments suggesting their reception will be hostile and elevated as compared to other groups transferred. The secrecy and opacity surrounding these arrangements should deeply concern this committee. They suggested deliberate obscuring of conditions and process on the basis there is something to hide in defiance of public accountability and transparent government. This secrecy also affects individuals, and the Federal Court has found the government put a false or misleading position to tribunals by not providing the whole truth about Nauru, depriving people of proper consideration of the risk and consequences of the tribunal decision. To conclude, these defective and roughshod laws are causing irreversible intergenerational harm. Children have witnessed violent, ice-like redetentions of their parents. Family members have required hospital treatment after loved ones disappear without notice. One client tells us after Border Force came into their home when they were sleeping, his children are having lasting problems. His son has autism. He has nightmares about his redetention and sleeps with the lights on. If there is any noise in the house, his mother has to try to calm him down. Our clients describe feeling like they are on death row, that their families and lives are being taken piece by piece. The committee has a unique opportunity to hear these voices and apprehend further harm. The task of the committee is to confront whether it is ever appropriate for the executive to impose lifelong exile extrajudicially in secrecy without risk-based justification and without due process and at inordinate human cost. Irresponsible lawmaking to avoid judicial oversight is corrosive to the rule of law that protects us all. If we are prepared to exile long-standing community members without due process, where does it stop? The policies and the euphemistic resettlement cannot be salvaged. This iteration and the continued vilification of people based on country they were born is senseless and untenable, and it must be abandoned before more harm is done. Instead, government should prioritise a functional, humane, evidence-based system characterised by due process and integrity. These are policies and actions future generations will judge us on.
Fantastic. Thank you very much for your opening statements. I'm very conscious of time, Senator Cox, I'll give you the call first. If you can keep it to 5 minutes, I would be incredibly grateful.
I will certainly try for you, Chair. Thank you all for providing your opening statements to us today. I think I'll start with the general discussion around regional processing and I suppose put to all of the witnesses that are here today that we know the harm, the dangerous journey of people, particularly who've taken that journey by sea, that regional offshore processing in particular has all but ended some of that. And I'm keen to understand if there are any circumstances which particularly the Refugee Council would support the processing of asylum seekers in our region. But feel free for other witnesses to also comment.
Yeah, I'm happy to start with that. And again, I think I would point the committee to the Caldor Centre's submission. I think the evidence that offshore processing has played a part in stopping boats is fairly negligible compared to evidence of turnbacks and other measures. So I think the fact that we're spending hundreds, if not billions and billions of dollars to harm people with no end game should not be part of a strategy to try and stop people from making dangerous journeys, and there are certainly other alternatives highlighted in a number of the submissions. I think UNHCR also in its submissions talks to when it is appropriate to engage in sharing of processing, particularly regional processing. I think that can only be done when there is a system where people's human rights are fully respected. And I think clearly the evidence that has been presented to this committee by all of us sitting here, but by I think many of the submissions demonstrates that that is not happening in this circumstance. And that I think is where we have grave concerns around this policy, and I think the evidence we heard from Mariam demonstrates, in fact, the extreme lack of rights that people have, the extreme human rights abuses that people suffer through this policy makes it so outside of any realm of appropriateness that I think it's not even, it's an externalisation policy as opposed to any form of regional sharing of responsibility. But happy to let others respond.
Australia's policy of offshore processing has not saved lives. It has simply pushed the death offshore behind a veil of corruption and secrecy. If the Australian government is genuinely committed to saving lives, as it should be, then it should dismantle offshore processing and provide real pathways for people to seek safety. As a start, this should include increasing our resettlement program and providing fair processing for people to have their claims assessed within the community. For example, in the 2026 to 27 financial year, the government is only intending to allocate 20,000 places for both offshore and onshore humanitarian visa grants. This is simply not enough.
I would also just like to point out that I've been at the ASRC for 16 years, and 14 years ago I sat before the expert panel, of which there were recommendations to start regional processing again, and there were vast of evidence then that provided alternatives to setting up offshore processing. There are a range of other more humane avenues and levers that governments had. As Laura has mentioned, increasing the humanitarian intake. There's also investing in search and rescue. There is also currently a ban on resettling any refugees who are currently in Indonesia. So if you look at why people seek asylum by sea in the first place, there are ways that we can address that. And you can't address one tragedy of deaths at sea by creating other tragedies, which is offshore detention. There have been 14 deaths as a consequence of offshore detention, and you've heard in situations such as Mariam and in the evidence of the harm that is inflicted on people. So this policy of offshore detention is a moral and financial policy failure and needs to end.
Thank you. I'll pick that up as part of the line of questioning that I have. And as you heard from the Chair, I only have a very, very short time of 5 minutes, so I want to try and get through that. Obviously, we do have a migration program as part of the Australian government that those refugee places, I would hope that everyone here today agrees that they should and do go to refugees, and that the issue of people seeking asylum is a different issue, and that in those instances cannot then be offered or given those refugee places. So, I hope that that is something that witnesses. I'm happy for you to comment on that, but that is the current situation, and I know that you've talked about increasing the intake, but if anyone would like to make a comment on that, I'm very happy for you to.
I think one important thing to note is that Australia is one of the only countries that links its onshore and offshore protection as part of humanitarian resettlement, which means that people who are granted humanitarian visas offshore and those who then seek asylum in Australia and are recognised as refugees, it comes from the same pot, to put it very simply. And I'm sure Graham can expand on this, but that could be easily solved by delinking our onshore and offshore protection visas and humanitarian visas and having them as two separate groups so that you are not removing places from our humanitarian resettlement with those who are forced to seek asylum onshore because they have no opportunity to come through the humanitarian program. So if I've understood your question correctly, I think I agree with you that the places should be kept separate, but unfortunately that's not the position of the Albanese government currently. But Graham, you may want to comment more on that.
Yeah, and again, I think just it's important to reiterate that our onshore program is part of our convention obligations. You know, as a signatory to the Refugee Convention, we have said we will provide protection to people who come onshore and claim asylum. So that's part of our international obligations, which is what we do. As Jana says, unfortunately, that is then linked to our offshore humanitarian program. And so sadly, that limits our humanitarian program, which is one of the solutions that's been identified as a way to stop people from getting on boats. And we have a number of examples. Australia has now started resettling Rohingya out of the camps in Bangladesh, in Cox's Bazar, one of the biggest camps in the world. We've only just recently, again, a couple of weeks ago, seen another 250 Rohingya drown trying to get to safety because of the conditions in those camps. And without governments like Australia providing hope, we will see more people getting on boats and more people drowning. So resettlement does save lives. But if you are going to limit our program by linking it with our onshore obligations, that's when you start pitting refugee groups, both equally deserving of protection, but should not be pitted against each other in the way that our numbers are calculated in this country.
Great, thank you. I just want to pick up the thread quickly. I don't have very much time left. Around some of the concerns that you raised in your submission, around the contracts for service provision, which relate to contracts signed before 2022. That was something that wasn't identified, is that correct, within your submission?
We have identified a number of the examples in our submission, as have others, but I think, you know, the Richardson review provided some extraordinary evidence around some of those concerns and how those contracts came about and the lack of due diligence. And I know the department in its submission is going to talk to how they've improved the due diligence around contract assessment, etc. But I think the history of what we've seen, as highlighted by my colleagues at this table, is that again and again, when you're talking about governments which are so embedded in profiting from these contracts, which is some of the evidence that we've provided, then this is why things will ultimately go wrong. History has shown us that will happen, and being able to keep an oversight of what is going to be $2.5 billion in the next 30 years for the one group alone, 70 million a year, let alone the $700 million we're talking about for the 90 to 100 odd people who have been intercepted by boat. It is a recipe for disaster, and that's what our submission has highlighted. And I would also draw the committee's attention to the Richardson review, which no doubt you have all already seen, but I don't know if others, I know.
Yeah, and just to clarify that certainly I can just speak to our submission that we've raised concerns about contract providers pre-2022, but also since then and continuing at the moment. The current contracts we've raised issues with as well in our submissions.
I mean, just one example.
So there's only 3 since pre-2022. Just to clarify that point, everything else was signed pre-2022 was the point that I was trying to make. There's only 3 contracts since then.
Those are significant contracts post-2022 though.
Yeah, there's the significant ones, but then there is also the ability for those companies to get subcontractors, and who those subcontractors are and where that money goes is something that I think this committee needs to be very, very aware of, and certainly try to drill down, because that evidence is not there. That's why the evidence is difficult to find because we don't have that independent oversight, which is something that the Richardson Review highlighted. To give one example, under the previous contract, the CanStruck contract, they were spending $400,000 a month on accommodation for their staff. And yet everything on Nauru is privately owned. So who on that small little island, which families are able to get those contracts and get that money, starts to play out politically with some of the evidence. Again, this is historical evidence from 2016 around the president of Nauru ensuring that his cousins are provided with serious, and again this evidence is in our submission, are able to get some of those contracts. So it's that subcontracting that goes on that the Australian government and the Australian people need to be aware of. Where is that money going? And evidence time and time again, which has been highlighted, has demonstrated that when you play in these environments, as we saw in PNG and again here, it ends up going to some very, very dodgy places.
Okay, and I'm aware that some of those are no longer providing services on Nauru, is that correct?
That is correct. So, but again, the breakdown of the current contract is something that we would like to see. And again, it's all commercial in confidence. So exactly where that money is going to, we no longer can see how much is spent per month on accommodation for MTC staff. That is not publicly available information. It was under the previous contract, which is why I can quote it. But we don't know what's going on now. And without independent oversight, we don't have the ability to see where that money's going.
And across those three contracts since 2022, it's over $2.5 billion. So there's still a significant amount of Australian taxpayers' investment since 2022 that is going to uphold the harm and suffering that is offshore detention. Okay.
I'm probably going to get the push from the chair. I can feel her. I can feel her. I'm trying to let it go down and say, "This is your final question." Yeah. I just want to put to those witnesses that are here today, and Miriam, can I acknowledge your evidence as well today? Thank you very much for appearing for the committee as well. But one of the questions I have, just to finish off this this panel, was that the 100% of people that were I suppose liable, I'll use that word, for third country settlement in Nauru, had their visas cancelled due to serious criminal convictions since their arrival in Australia. Do you accept that that's the situation in which they were put there?
Sorry, I didn't get what you mean.
No, sorry, that was to other witnesses, not to you, Mariam, sorry.
Thank you, Senator. Some of the people who are being considered for removal to Nauru have criminal offending in their histories, some but not all. Our strong position is that they are in no different position than anyone else of that profile in the community, subject to the same laws, and they should be subject to the same treatment. If we don't adhere to the principles of equivalence of justice, we start to see a tiered system of justice based on country of birth. And it's our view that the structure of our legal systems, of our support systems, of our medical systems adequately provide for protection of the community in all cases, regardless of a person's country of birth.
Thank you. And I suppose I just wanted to note in all of the group that also have lived in PNG since 2014. Many, as noted in your submission, have partners and families in Port Moresby. Does that demonstrate that some of these people have integrated into the PNG community?
I'm happy to take that one. I mean, I think the short answer is no. I think for perhaps a handful, maybe, but we are still hearing weekly, if not daily, the fact that these individuals, despite having a PNG wife and children, are still subject to physical violence because they are clearly different, and the family protections still really do not apply to them. So their ability to find jobs, to find accommodation, to live safely in the community in one of the most dangerous cities in the world has proven to be false. And so these people are still, a number are still in a pathway to New Zealand, but some of them are so damaged that they won't be able to go anywhere. And this has been acknowledged by the Australian government. But yeah, the extreme violence that they face on a daily basis, the fear and the trauma that they are suffering, that is ongoing. And yes, they might have found someone and fallen in love and had a family, but the violence that they are experiencing because they are foreigners is very, very real.
And sorry, if I can clarify, because we also refer to men in Papua New Guinea and their partners and children, and for many of them it's actually their partners and children from their country of origin who have been reunited with them on the understanding that they would then be resettled as a family, but they haven't been yet. So just to clarify that the reference to partners and children are not just in relation to those who have Papua New Guinean partners and children.
Okay, thank you. Thank you, Chair.
Thank you very much. It's the longest 5 minutes ever, I think. But look, I just have one question, and then the rest I will put on notice for timing so that Senator Shoebridge has an opportunity to ask questions. I guess there are objections to third country arrangements that I'm hearing. Are those, I guess, objections in principle, or is it just how the current process is? Would you accept third country processing if all of the sort of flaws in the system were ironed out?
Well, there's 14 years of trying to iron out a system and it is still incredibly harmful. So based on the evidence of 14 years, I would say that any form of offshore processing, which is offshore detention and third country resettlement, however it's referred to, is damaging and harmful. It also breaches our international obligations, saying that when people seek safety in our country, we would process their claims here. So there is just ream and ream of evidence of 14 years. This is also the second time that an Australian government has used offshore processing, and it's the second time it's failed. So all the evidence points to this being a completely failed policy.
And I would like to return to my opening statement. The fact is there is no end game for this. The 90 to 100 people, again, we're talking about two different groups, but if we're talking to the 90 or 100 people who are intercepted at sea, there is no end game for that group. There is nowhere for them to go. If the current government policy is that they will never, ever, ever be resettled in Australia, as it is for the 750 or so transitory people, such as Mariam, then you are talking about a policy that is going to keep people in limbo forever. And so there is no third country resettlement. Despite the Department of Home Affairs submission, there is no third country option available to recognise refugees who are in need of protection at the moment. And so talking about ironing out the kinks, does this mean you're going to talk to President Trump and tell him to start resettling people again? Are you going to convince the New Zealand government that they should offer us another 450 people? Should we tell the Canadian government that they should in fact fix their complementary pathways so that New Zealand citizens can sponsor people again, funded by Australian taxpayers who've supported our Operation Not Forgotten? You know, these are the complexities we're talking about when we're talking about ironing out the kinks. It's a policy that has no end game for human beings who are suffering offshore in secrecy.
We would agree with those comments from our colleagues and just briefly add that after 14 years, it's a political fiction to expect that offshore processing can somehow be reformed into a system that is acceptable.
Thank you. Senator Shoebridge.
Thanks very much, Chair. I think going to those questions, the lesson of 14 years of this is that organised cruelty basically requires organised crime and corruption to deliver. That's probably a fair lesson to take from all that we've seen with what's happened to billions of dollars of public money and what's happened to people on the ground. These things seem to be connected, don't they?
That's exactly right. If organisations of questionable integrity are the only ones willing to accept a job, then we need to ask ourselves how compromised that job must be.
And the disclosures we've had in the last 12 months about bikie gangs being used, about this running cover for drug dealing, and then just the basic brutality that's been delivered on the ground in Nauru. There does just seem to be that connection between some of the worst organisations on the planet and official government policy. That connection seems to be being demonstrated, doesn't it?
And you have to remember the only reason we know about that is because of whistleblowers or a 60 Minutes expose. That's the only reason that we've got this hearing today, is because it's almost impossible to get any information as to what is being done with taxpayers' money. And if it sounds like there's dirty deals, or it sounds like and sniffs like there's something wrong here, it's probably because there is.
And we've seen time after time, whether it's this government or the previous one, use public interest immunity claims to hide the contracts, hide the MOU, protect the subcontractors, prevent the Australian public from seeing what's happened with what now over the course of 14 years, $17 billion of public money. You know, when governments rely upon institutional secrecy, that should be a warning sign, shouldn't it?
Well, again, I would come back to the lack of independent oversight and why we don't have that. And I think it is extremely concerning that even UNHCR, given that both Australia and Nauru are signatory countries, UNHCR has not been able to return to Nauru since 2023, since the latest group of people have been transferred there. As per their submission, they put in a request to go in 2024, and they're still waiting to hear about whether or not they can actually go to a signatory country to see what is happening on that country. So let alone any other independent oversight in circumstances you've just described.
Mariam, first of all, thank you so much for the bravery you've shown in coming and telling the truth and breaking that wall of secrecy that the government tries to put up between the laws that this parliament passes, the budgets we pass, and what actually happens on the ground in Nauru. And I just want to give you my personal thanks for the bravery and to tell you that you've been heard. Do you have a message to the politicians in this place that make these laws, that have produced this impact on you and those people you were with in Nauru?
Honestly, after 13 years, it's hard to deal with my emotion because I'm living in limbo. Every morning, I don't know what will happen today. To me, to my husband, my little one, you know. I think the politician has power to change this law. This cruelty, we are just human, innocent human kids, women. We don't put government down. We all working hard to be as part of this community, just be part of this country. So we are just looking for a safe home. Myself and 700 people who are still in community with temporary visa, we are living in limbo without any certain future. Some of us, we have kids who are citizens. Some of us, we have a partner who are citizens. Some of us, we have family here. After 13 years, we are all devastated. We are all tired of fighting. And we know you have power to change this law. This law didn't work. I don't think this law, the 19th of July law, which Kevin Rudd decided to send us to Nauru, worked. You could return boats to the original place they came, but every day in Nauru, we wish to die in the sea. It was better than living in Nauru. It was end of the world for us. Nothing beyond this, that hell. You can't imagine how we are shattered, we are exhausted, we are tired. Some of us, we couldn't even move. It's so devastating, The only thing I ask you, you have power to change this law for our safety, for goods. We just want to be part of your community, your country. We want to be here in Australia as a home. My son knows Australia as his own country. Even if someone asks him, where's your nationality? What's your nationality? Where are you from? He says, Australian. I'm Australian. I'm from Melbourne. How can I explain this situation to him, to 7 years old boy? He can't understand.
Well, I mean, I hope we get to a point sooner rather than later where his mum is also safe. I hope we get to that point sooner than later.
Thank you.
Thanks,
I hope so.
Yeah. To any of the panel, but there have been a number of first-hand submissions put in, I think attached to your submission, Ms. Rivera, that detail what life is like on Nauru at the moment for people, and acts of casual violence, indifference from the police, this sense of, very real fear about their personal safety. Can you take us through what you've heard about life on Nauru at the moment for people that Australia send there?
So as our submission details and the submissions attached to it, we're currently in contact with 90 people who are on Nauru. Some of them have been there for weeks, some of them have been there for over 2 years. And the constant thing that they all report to us is that they're living in fear. They're not sure what will happen tomorrow, the next day. There have been incidents where people have made reports to the police that haven't been followed up, where police statements have gone missing. As I mentioned, we did a health audit where over 90% of people have said that they have physical and mental health conditions. The medical neglect is continuing. As Graham said, Nauru is the size of Melbourne Airport, mainly with areas that are uninhabitable, and a lot of local Nauruans. They don't want people who have been forced on their country to be there, and that plays out. And that's not blaming the Nauruans at all, it's just the reality of the situation. So life is tough. They don't have enough food, they don't have enough clean drinking water. There are animals and beetles that are in the drinking water. They're dehydrated. A lot of the conditions and medical conditions are man-made and created because they're on Nauru.
Well, we heard from Mariam and about just the unsanitary conditions, the lack of access to clean water, the lack of access to food. Now, Mariam was talking about her experience from some time ago. Is that still the situation on Nauru, those same conditions?
Yeah, when I heard Mariam speaking about the situation that she was facing on Nauru over a decade ago, I was reflecting and thinking that's exactly what we're hearing today, the same thing, people not having enough food to eat, the drinking water that is unhygienic, there's not enough food, you can't get access to fresh fruit and vegetables, people are getting sick and then it's not being treated and so they're getting sicker and their medical issues are being compounded, they're then not seeing a doctor. So the conditions on Nauru and the mistreatment and neglect of people is continuing today.
And these are the conditions that this government is deliberately sending people into, deliberately send them into conditions where they're likely to be hungry, dirty, unwell and scared. And that's what you're hearing on the ground.
It's well documented through, Mariam's story and the other submissions, what the conditions are that people are being sent to, and we have continued to raise our concerns over the past 14 years and over the past days and weeks with the department and the current government as to the conditions that they are subjecting people to. They know.
The implementation, Senator, of the third country reception arrangements and the escalation of policies around that indicate that nothing has been learned. The conditions are expected to be worse than they have been historically, which is saying a great deal. And the way that has been structured indicates a lack of interest in resolving or improving those conditions for people.
And from an Australian taxpayer's point of view, the Australian public's point of view, it's additionally obscene, isn't it? Where billions and billions of dollars are being pumped into Nauru, notionally to keep people safe. But we hear that the people that Australia sends there don't have access to clean water, are hungry, are living with chronic health conditions. So where is all this money going? And I think that's a question where I think the Australian public deserves an answer to. It's obviously not going to the people it's meant to be providing support for, or at least notionally. Where the hell are these billions and billions of dollars going?
And again, you raise a number of issues. I think talking to the physical environment, the fact that the entire population lives around the rim, but there's no transport. So how do people actually get from where they're being housed, because they've got no choice around where else can they be housed, to the hospital, to the shops. 2 litres of milk are currently $24. And yet the stipend that they get...
Sorry, did you say 2 litres of milk is $24?
24 Australian dollars. And yet when you think of the minimal stipend they get, this is why people are going hungry. When Jana talks about people going hungry, it's because they can't afford to pay. Everything has to be imported to that country. And there have been shortages of rice that the Australian government has had to step up in terms of providing aid. On top of what we're providing through these contracts, we've had to provide aid to feed the Nauruans, who then get very angry that there are these other people foisted upon them who are taking the limited food that's on the island.
It is obscene. It's obscene that with $17 billion, there's not even adequate food on Nauru. It's obscene to a degree it's hard to explain. Just because we've got limited time, Ms. John, your submission talks about other ways in which the secrets are being kept and people are being silenced. You talk about non-disclosure agreements. Can you talk us through that?
That's right. So at the Human Rights Law Centre, we are aware of individuals with direct knowledge of matters relating to the terms of reference of this inquiry who actually felt inhibited in being able to make a submission to the committee. And now that is because of the use of widespread secrecy provisions in Commonwealth legislation and also non-disclosure agreements amongst government contractors. In our written submissions, we provide one example of an agreement that makes a breach of confidentiality obligations a criminal offence. As you'll be aware, Senator, parliamentary privilege provides some degree of protection, but its operation is very uncertain and there are significant barriers to whistleblowers being able to access support and independent advice. So in this context, the committee cannot be confident that people with information relevant to the inquiry feel able to come forward. Now, we would suggest that there are 2 things the committee could do to rectify this. The first would be to make recommendations in this very inquiry that the widespread use of secrecy facilitates some of the wrongdoing that this inquiry is considering. And the second is, in the future, considering seeking a government undertaking to waive the confidentiality obligations in those non-disclosure agreements. There is precedent for this in previous inquiries that committees have undertaken, and this would go some way to enabling a committee to properly investigate these serious claims of corruption.
So just to be clear, it's your understanding that there are people who would have liked to come forward and give evidence to this committee, tell the truth about what's happening, and they're in Australia, but they're scared that our own government will put them in jail if they spill the beans.
That's right. They're concerned that the agreements they have been required to sign connected with their employment, that the legislative framework in Australia prevents them from being able to come forward and speak out against wrongdoing.
So not only do we have the government hiding the memorandums of understanding, refusing to produce details about where the payments are going, they also have people who are part of this cruel system sign on to contracts which threaten to put them in jail if they tell the truth.
That's right. We have an infrastructure of secrecy in this country, and that infrastructure has been deliberately designed and deliberately maintained.
Yeah. And when you hear about the cruel treatment, the systemic cruelty, you can see why the government wants that secrecy. Because if the Australian public saw unvarnished what was happening in their name, they'd no doubt be revolted.
It's precisely this history of abuse, mistreatment and secrecy and this environment that has created the conditions for corruption to thrive and also created the conditions for corruption to be kept hidden from the Australian public.
We are well past time, but I might just invite each of you to just briefly address this committee on what our job should be here. We've got all of this evidence. We've got the evidence that's come out in this hearing and in the public about deep-seated corruption, about systemic cruelty, about government secrecy. What do you think the task of this committee should be in light of all the evidence that we've received? And we might start with you, Ms Dickinson.
The committee has a critical job at this juncture. These policies are authorising detention by proxy, violent enforcement, secrecy, deterioration of conditions that are causing harms in our clients on a daily basis that I have never seen before in my career. The committee has a unique opportunity to apprehend that and to recommend offshore processing be dismantled and those people subject to it return to Australia. It's not complicated what we need. We need a humane migration system with integrity that works as intended, that doesn't produce consequences that no community member would accept. That's what's happening now. What we see would not be acceptable to the Australian community. The treatment of our clients, of their children, the distress of their mothers, the fear they live with every day, the breakdown of their mental health that erodes rapidly in detention. We ask that the committee give its full consideration to what is being done to people and does what it can to push us towards reform.
Thanks, Ms Dickinson. And I can hear the chairs in my right ear, even if you can't. If we could possibly be, punchy and brief, and we might go to Mr Tom, and then we'll come to you, Mariam, and then we'll do Ms John and Ms Ferrero. Mr Tom?
Yeah, conscious of time, I think, again, it is clear that this policy is unsustainable. If we're going to have a policy with no end game, then we are only ever going to see abuses continue. And I think this is where we need to ensure that there is full transparency, that there is an opportunity for people to actually make sure that their claims are heard in a way that ensures that their human rights are respected, and that should happen onshore. It is clear that any alternative is only going to be open to abuse.
Mariam? You're still on mute, Mariam.
In Naro, I would say how much harm has been done to people, kids, we, especially women, young girls, children have been groomed, women sexually assaulted and harassed and abused. How government can fix those things?
Thanks, Mariam. Ms. John.
I'll be very brief. The committee should recommend that offshore processing be dismantled. Permanent safety should be provided to every person who has been subjected to it, including the 700 or so people like Mariam who are in Australia, still in permanent visa limbo. And the new third country reception arrangements with Nauru must be immediately terminated, and the people already deported under that regime brought back to their homes and families in Australia.
Thanks, Ms. John.
The committee has a rare opportunity to put a spotlight on the harms that are created by offshore detention, and the only way to fully expose the misconduct and the moral and financial failure is to compel documents. This committee has the privilege of access to information, and I believe if that information is uncovered, then there would be no other recommendation other than to end the harmful offshore processing and resettlement and provide permanency to all people who have been subjected to it.
Okay. Thanks all. Thanks, Chair.
Fantastic. Thank you very much, and thank you all for coming in and giving evidence today. We really do appreciate it. If there is anything that you have taken on notice, so answers that we've asked to be provided on notice, if you could provide that to the committee by the 18th of May, we would be very grateful for that. So thank you, and with that you are released. We will now suspend until 1:40 p.m. Thank you. Thank you very much. I now welcome representatives from Overseas Services to Survivors of Torture and Trauma. Thank you for taking the time to speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I please ask you to state your full name and the capacity in which you appear?
My name is Bernadette McGrath and I'm the CEO of Overseas Services to Survivors of Torture and Trauma.
Fantastic. And do you have an opening statement?
Well, as we stated in our submission, we don't support or agree with the arbitrary and prolonged detention of asylum seekers, particularly in offshore locations. In our experience, it causes extreme and long-term psychological harm and should never be resorted to.
Fantastic. Thank you. So you're happy for us to go straight into questions then?
Yes.
Yeah, excellent. Senator Cox, would you like to start questions?
Senator Stewart might be taking this one.
Is it Senator Stewart? Sorry, Senator Stewart.
Yeah, thank you, and thank you for appearing today. I'm keen to understand a bit about the teams that you have, if that's okay.
Sure.
And just want to ask what were the size of the teams that went to Nauru and Manus?
On each island we had a team of 3 counsellors working, and there were always 2 counsellors on island at any given time, and they worked in rotation.
Yeah, okay. And what do you mean by rotation?
A team of 2, so it was a team of, so it's 3 people, and 2 would be on island at any given point. So they'd work on island for 4 weeks, take a 2-week break, and the third, and they would kind of, be staggered.
Yeah.
Staggered rotation.
And how were so you said 3 counsellors. Does that mean the teams, because I've got a question here that's asking about how were the teams broken up. So were they all clinical?
Yes. Yeah. They were all experienced torture and trauma counsellors from the Forum of Australian Services for Survivors of Torture and Trauma. So we drew on that network to provide experienced counsellors, practitioners.
Mm. And can you explain to the committee how referrals move through your organisation?
We would receive referrals from IHMS in the first instance. So IHMS nurses, medical staff or mental health, psychologists, psychiatrists would refer to us. And in the community, people could self-refer or they could be referred by other organisations such as the welfare provider or the security services or whatever other services could refer to us.
Okay, so you can get
self-refer.
Yeah, okay, so you can get incoming in multiple ways.
Yeah.
And then how, so what happens at the point of referral? Can you explain to me kind of how they then get to see a counsellor?
Sure. Well, we would accept the referral. They would be basically allocated to the next available counsellor. That counsellor would provide an assessment and see whether they were, they understood what we could offer them, and whether their needs were able to be met by our service or at least partly met by our service, and it would proceed from there.
Yeah. Okay. And is there a wait time in between?
Sometimes there was. When we first arrived on the islands, there was quite a significant waiting list on both islands, and at different points the waiting lists were quite extensive, and then but it varied.
Yeah.
Yeah. Okay.
I'd actually have to say that we would always have preferred to have more staff. We would have been able to do more if we'd had more people. We were always constrained by numbers.
Yeah. Okay. And what information goes back to the department in terms of the work that you do?
We never reported directly to the department because we were in a subcontract arrangement with IHMS. To IHMS, we would basically send what we called an advice that essentially stated, we're seeing this person, and the advice would be a very brief statement of their current mental health status as we assessed it, and then that would be it. We never reported the content of counselling sessions. We never reported people's history. That was all held confidentially, continues to be held confidentially.
Yeah. And so, and I can appreciate that as somebody who's a therapist myself that somehow ended up in Parliament. How in those instances where you're working with somebody where you've got concerns about their mental health status or worried more broadly, I suppose I'm wondering how risks or incidences are reported.
Sorry, you just dropped out slightly then. You're asking me how you
kind of manage or report incidences and risks.
Okay. Well, basically we had a scale, if you like, of and when someone reached what we referred to as a level 4 risk, and that basically meant that they had what would happen in Australia if someone reached that level of risk is that you would probably refer them to hospital. They would require it would mean that they were actively suicidal, essentially.
Yeah, okay.
And so in those instances we would refer to IHMS because IHMS had that's basically their area of work and they also had the facilities to be able to provide 24-hour monitoring if someone was actively suicidal. And also they have the capacity and, expertise, qualifications, etc., to prescribe medication and if that was what was necessary.
Yeah, okay. I don't think I need to ask the other questions here, but I suppose just finish by saying thanks to you and your team for the work that you do to support people when they're vulnerable.
Thank you.
Fantastic. Thank you, Senator Stewart. Senator Shoebridge.
Thank you very much for your submission, and we have a really short amount of time, so I'm going to keep questions very brief. Your service was on Nauru for a decade, between February 2013 and June 2023, is that right?
We left Nauru at the start of COVID. All service providers were asked to leave Nauru at that time. I think IHMS maintained a skeleton staff there. But we physically left Nauru then at the start of COVID, and we almost immediately commenced telehealth counselling. So we finished providing funded telehealth counselling in June 2023. On Manus Island, we physically left the island in 2017, but commenced providing pro bono telehealth services there in January 2018. So, and actually continue to provide services to the last remaining men in Manus. Oh, sorry, they're not in Manus Island anymore. In Port Moresby. And
with that experience, how many people do you think you've treated or provided support for who are survivors of torture and trauma?
between 900 and 1,000.
And you say in your submission that your extensive clinical experience has shown that offshore processing will intrinsically and unavoidably harm the mental health and wellbeing of individuals transferred under these arrangements.
Indeed.
Do you want to just tell us about that conclusion and why you arrived at that conclusion?
The harm stems partly from it stems from the arbitrary nature of the detention. It stems, and then as the years went on, it was very much exacerbated not only by the very harsh and unsupportive conditions in which people were held, but also just the length of time, the uncertainty that came with the actual processes for resolving claims took a long time, and there were no clear resettlement pathways for a long time. And then even once there were clear resettlement pathways, they were people had to embark on another process of being assessed for their suitability for resettlement in the US or Canada or New Zealand. And all the time people are being held in conditions that are extremely uncomfortable, often didn't meet their physical or mental health needs, didn't provide adequate opportunities for employment, education, separation from family, and all the time not having any kind of end date. Was probably the most destructive of people's mental health.
And your summary is that system is just inherently abusive. That's the conclusion you came to.
Any form of arbitrary or long-term detention is inherently abusive. It is certainly exacerbated by being held in poor, under-resourced, unsupportive conditions with no end date and no clear pathways to resettlement. Those conditions will take an already harmful set of circumstances and greatly exacerbate the harm, yes.
And to be clear, when we're speaking about Nauru, they are still the circumstances that you're observing as recently as June 2023, when you were last connected to the island. Is that right?
Most people had by then been transferred to Australia or to other to the US or Canada. Some had gone to New Zealand, and so there were only a few left. But those conditions continued.
Right. Thanks so much for your help today and for your evidence.
Fantastic. Thank you very much for appearing and giving evidence today. We really do appreciate it. So you are now released and we will suspend for a couple of minutes.
Okay.
I now welcome representatives from the Management and Training Corporation and International Health and Medical Services. Thank you for taking the time to speak with the committee today. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I get you each to state your full name and the capacity in which you appear? And we might start at this end, Ms Conway, if I'm reading terrible eyesight, with you, and we'll work along. Thank you.
Thank you, Senator. My name is Ms Brioni Conway. I am the Regional Contracts Manager for IHMS.
Thank you, Senator. My name is Dr Deki Savanavong, and I'm the Medical Director of Government Services Pacific for IHMS.
Thank you, Senator. My name is Sybil Wishart. I'm the General Manager for IHMS.
Thank you, Senator. I'm Ian Gilbert. I'm the Regional General Manager for IHMS and also the Chairperson and Company Director.
And then we've got some people online as well.
Senator, my name is Troy Edinson. I'm Managing Director of Management and Training Corporation Australia.
Thank you, Senator. Siddhartha Mehta. I am the Executive Director, Business Services for Management and Training Corporation.
Fantastic. Sorry?
Sorry, Mr Mehta, what did you say your position was?
Executive Director, Business Services. Thank you.
Fantastic. Thank you very much. Now, do you have opening statements that you would?
Yes, we do, Senator.
You do? Please commence when you're ready.
On behalf of IHMS, I'd like to thank you for the invitation to appear before the committee. We acknowledge the traditional owners of the land on which we meet and show our respect for elders past and present. IHMS has been providing healthcare services in the offshore processing environment since 11th of December 2022. For the purposes of this inquiry, IHMS has been contracted since the 13th of August 2022 under the Nauru Health Services contract to provide healthcare services to refugees and asylum seekers living in the Nauru reception facility or in the Nauruan community. We are also contracted to provide healthcare services to named recipients to the contract. These recipients vary from time to time, but comprise Australian government officials and other service providers working in or visiting Nauru. This contract is currently until the 12th of August 2027, although there is a maximum 1-year extension opportunity still remaining for the Department to extend the contract to 12th of August 2028. IHMS is not contracted to deliver health services to the NZYQ cohort who are in Nauru for resettlement purposes. The Nauru Health Services contract is highly prescriptive, governing every dimension of service delivery from clinical governance and workforce credentialing to incident management, pricing, performance abatements and audits. It has a defined scope, defined governance interfaces and defined reporting obligations. Performance is monitored and managed by the Department and IHMS through a formal performance management framework. The performance requirements comprise a broad range of metrics, including healthcare delivery and timeliness, preventative health services, complaints and service feedback, incident reporting, mental health screening and assessment, work health and safety, as well as quality of healthcare records. Performance failures attract financial abatements and require the implementation of action plans. IHMS policies, procedures and clinical practice guidelines are based on the Royal Australian College of General Practice, that's the RACGP, standards for health services in immigration detention. Although the healthcare services in Nauru cannot be formally accredited to the RACGP standards due to being outside the Australian jurisdiction, our clinical services broadly align with these standards. IHMS, including the IHMS clinic in Nauru, is accredited to ISO 9001-2015 Quality Management System and ISO 45001-2018 Occupational Health and Safety Management System standards. In addition, IHMS has a formal quality management system to audit, evaluate and improve the activities of the business. Under the Nauru Health Services contract, we are required to maintain scalable readiness for a remote and variable operating setting. Our staffing model is a banded model with agreed staffing levels aligned with a defined state of activity in Nauru. There are 3 states of activity: baseline contingency, heightened contingency, and active state. Under the active state, there are 8 different bands aligned with transferee numbers from between 0 to 1,000. We are required to move rapidly between bands and scale up or down our service offering within very short timeframes. Maintaining this mobilisation readiness on a remote Pacific island demands extraordinary operational sophistication. IHMS must retain credentialed personnel pipelines with deployment-ready clinicians, maintain pharmaceutical supply chains with assured cold chain integrity across vast distances, sustain clinical governance systems and ICT infrastructure in continuous operational condition, preserve freight and logistics arrangements capable of rapid activation, and keep medical evacuation pathways current and exercised. In accordance with the current band of between 51 and 100 transferees, our multidisciplinary team of 20 staff, of whom 18 are clinicians, in Nauru consists of 1 health services manager, who is a senior registered nurse, 1 emergency medical officer, 1 medical officer, 1 psychiatrist, 5 primary healthcare nurses, 2 of whom are after-hours nurses, 1 mental health team leader, 3 mental health nurses, 1 torture and trauma counsellor, and I should mention the mental health team leader is also a torture and trauma counsellor, 2 paramedics, 1 laboratory technician, 1 radiographer, 1 administration officer and 1 health facilities officer. Australian-based staff predominantly occupy leadership and nursing roles, ensuring alignment with clinical governance frameworks and national standards. Internationally recruited personnel, predominantly from South Africa, the Philippines and New Zealand, provide essential capability across medical, primary care, diagnostic, imaging, emergency and specialist mental health services, while locally based staff strengthen operational coordination, facilities management and service continuity. All staff are engaged in accordance with relevant credentialling, registration, including by the Nauru Medical Board as well as their home countries, and regulatory requirements. If we determine a refugee or asylum seeker requires access to specialist care which cannot be provided on Nauru, either by IHMS or the Nauru Medical Centre, or via a telehealth consultation, IHMS will recommend transfer for specialist medical care to either Australia or to Taiwan. That request must be approved by both the Government of Nauru and the Department. Since the commencement of the current contract in 2022, all requests for transfer have been approved. IHMS staff come from a broad range of cultural backgrounds and many have prior experience in the delivery of refugee health services, including in international settings. This workforce diversity helps to ensure the application of cultural sensitivity and compassion with client groups. IHMS staff are highly committed and dedicated to the provision of high-quality healthcare services in this complex and challenging environment. This commitment is demonstrated on a daily basis. Thank you once again for the opportunity to appear before the committee.
Fantastic. Thank you very much for that. The MTC, do you have an opening statement?
Yes, I do. Thank you. And I'd like to take this opportunity and thank you on behalf of Management Training Corporation to participate in the committee hearing. I'd like to acknowledge the traditional owners of the country of Australia and the continuing connection with the land, sea and community. Pay respects to them, both elders past and present and emerging. I'm in Brisbane, so I'm in the Jagera land. So I just want to acknowledge the Jagera people. The Nauru Facilities Garrison Transfer Arrivals and Reception Service Contract is an Australian government agreement with Management Training Corporation Australia, known as MTC Australia, to provide services to transferees in Nauru. The initial 3-year contract was awarded to MTC in late 2022 and was extended by 2 years on the 30th of September 2027. In July 2023, an independent review led by Mr. Dennis Richardson, AC, examined the integrity and concerns of the government arrangements relating to the management of the regional processing administration contracts by the Department of Home Affairs. The review assessed procurement processes, contract oversight mechanisms, integrity controls, and governance structures supporting the delivery of the services under the contract. The findings confirmed that the fundamental contract controls and oversight mechanisms were appropriate and structurally sound, supporting confidence in both procurement integrity and the ongoing contractual management arrangements. Importantly, the review identified no evidence of deliberate wrongdoing or corruption, affirming that the contract was lawfully awarded and subject to robust governance and assurance processes. The review further reinforced that the governance framework underpinning the contract delivery provides oversight, transparency and accountability, enabling the Commonwealth Government and the Australian public to have confidence in the integrity of the contract execution. While opportunities were identified to strengthen cross-agency information and sharing enhancement of certain risk management practices, these were forward-looking improvements designed to mature an already adequate and an effective framework. They do not detract from the integrity, compliance and performance of the contract. We remain committed to continuous improvement, proactively incorporating lessons and enhancements to further strengthen transparency, risk management and governance maturity. This commitment reflects our focus on delivery of services lawfully, ethically and in line with public sector expectations. In the execution of this contract, we pride ourselves on the delivery of integrated facility and welfare services and prioritise care, accountability and operational excellence. Our approach spans the accommodation of security, community services, logistics, staff development and a continuous focus on improvement for positive outcomes for the clients, staff and the wider Nauruan community. Embedding a culture of care, responsibility, ethics, transparency and accountability, we ensure that services are delivered efficiently, safely and in line with government oversight of the transient populations. To support the development enduring capability as required by the contract, MTC Australia subcontracts a range of services to local providers. Please note that all these subcontractors are in line with the recommendations made by the Richardson Review and are subject to government reviews and endorsement. All subcontractors' invoices are subject to a service level agreement and valid invoices are paid on electronic bank transfers. For the committee's information, I often travel to Nauru and recently returned from a trip to Nauru, and I'd like to take this opportunity to thank the MTC staff for the work they do in difficult circumstances and the fact that their fly-in, fly-out arrangements do take them away from their family. I'm very proud of the work that we do. Thank you.
Thank you very much. We'll now move into questions, and I might start with Senator Cox.
Thank you very much, Chair, and thank you to both of you for appearing with us here today. Can I just get you to outline for the committee some of the contract controls and the oversight mechanisms used by MTC on managing this contract?
I think I'll defer to my colleague as a business executive.
Thank you, Senator. Thank you, Troy. As we stated in our opening statement, Senator, MTC prides itself on a robust process in place which identifies, verifies all the services that have been subcontracted. One of the important things that we are proud of, all transactions are individually verified, and all invoices in relation to those services provided locally are verified as well before any payments are made in those particular services.
That's great, thank you. In Nauru, can you provide a breakdown of the different team structure within the regional processing centre, please?
So, can I just ask you, talking about the management structure on site?
Yes, please. And are there different teams that exist within that?
Yeah, so we have a senior leadership team that's on island, which is a contract manager. We have an accommodation manager, an operations manager, and a welfare manager, and as well as a security manager. So they're the senior leadership team on island. We have a team of security staff, which are a combination of Australian expats and local security staff that work under MTC. We have then the garrison support team, which is this team that does all the maintenance for the facility. And we have a welfare team that is in charge of case management of individuals within the facility. And we have a catering team as well that provides the services and provisions for the facility. So they're the broad groups. But just to give a little bit more clarification, each one of them are in different rotations. So the senior leadership team have a roster of 8 weeks on, 4 weeks off. This is to ensure that we have a high level of senior leadership team across the contract at all times. Then the security staff work a 6 on, 3 off roster, with our maintenance staff doing a 4 on, 4 off roster.
That's great. Thank you very much for that. And just in relation to subcontractors in Nauru, can you explain to the committee the process between the subcontractor, MTC and the Department of Home Affairs for us?
So the contract requires that we provide a level of subcontracting for locals so that we have a due diligence process for procuring local subcontractors. So then we go through a subcontracting process, which then includes a due diligence, executing of a service level agreement with that entity. Also, they have to provide a range of documentation, conflict of interest, before we then provide that to Home Affairs for their endorsement. So all of our subcontractors go through a due diligence process, then go through to the Department of Home Affairs for endorsement. Then we onboard them, and then as we've said, there's a due diligence process for services that are delivered, that we ensure that we're only paying for the services that are delivered, and we confirm that those services are delivered. An example would be the amount of water that's supplied to the facility at any one time. We have confirmation of delivery, and then the invoices are then paid once that we've gone through the diligent process of ensuring that the services have been provided. Then we go through our payment mechanisms through the Department of Home Affairs before we actually do the payments.
That's great, thank you. And are there any specific ways in which you, apart from what you've already detailed for us, but specific ways in which you manage subcontractors at Nauru?
Without going into specifics, I'd say that what we have is a direct relationship with the engagement of the subcontractors through our business services manager in Australia, so the SID, who's on the call now. And then he manages the subcontractors from a contractual perspective, and then from a deliveries perspective on island, it's the contract manager on island and the different disciplines depending on the services that are being supplied.
That's great. Thank you. That's all my questions, Chair.
Fantastic.
Thanks
Thank
very
you,
much.
Senator Cox. Senator Shoebridge.
Oh, yeah. Thanks very much, Chair. Thanks for your attendance here today. Could each of the organisations provide the current value of the contract? As I read on AusTender, for example, that IHMS, your current contract value is $106 million. Is that right?
That's correct. That's the 5-year estimate that's published on AusTender. I assume you're going to ask the next question, which is what's the current value in terms of the 4-year period? That's excluding GST. That's $83 million. Right. So if you look at the average of that spend over that period of time, it seems to be in line with the estimate provided on AusTender.
A bit over $20 million a year.
Yes, yeah, about 21.
21 million a year. All right.
And on track to meet that for the final year as well. MTC.
With the Department of Home Affairs putting the contract value, estimate contract value, we don't have an understanding of how that value was put on. But if we go to the next logical conclusion or next logical answer to that, the revenue we receive is around $85 million a year.
All right. So, I mean, you may not have wanted to say it, so I'll say it for you. AusTender has the contract value at $786 million. Is that your understanding of what AusTender has the contract until September 27 to be?
That's correct, yes.
And how much have you been paid to date?
I haven't got the figure to date on me. I'll have to take that on notice.
So you came to a Senate inquiry about your work involving offshore detention, core part of which is a contract for $786 million, and you didn't come prepared to tell us how much the Commonwealth had paid so far.
Sorry, Senator, I thought I answered the question by saying that it was average of $85 million that we've received so far.
So how much have you received to date of Australian taxpayers' money to provide these services on Nauru?
I'll refer to Sid Mehta for that.
Thank you. Senator, we would like to take that on notice, because then the reason for that is we consolidate our revenue stream on different contracts, including offshore and other contracts we have, and we would see what information we can provide.
All right. Well, I'll ask two questions then. I'll ask one, how much have you received for the services, the garrison duty work, the garrison management work on Nauru? How much of that $786 million have you received to date? And then if you're having trouble pulling that out, just tell us how much money you've received overall from the Australian government to date. Do you know how much that is?
Thank you, Senator. As I said, we would take that question on notice, and we would provide, and we will see what we can provide in matter to that particular question.
All right. IHMS, you say that you have a corporate goal of providing adequate care, I assume, to people on Nauru?
100%.
Yep. We've had multiple reports, evidence before this committee, of people held in Nauru who have had to, for example, exchange sexual favours for basic medical care. Has any of this been reported to you in your management of the contract? People so desperate for just basic care, having to trade sexual favours?
For the timeframe for this inquiry, so from 2022 until today, we haven't had any allegations brought to IHMS of any sexual harassment or sexual abuse by either IHMS staff or anyone else. Prior to 2022, we have received reports of sexual harassment and sexual abuse. Any of those reports that were brought to IHMS were thoroughly investigated by IHMS. Reports were made, and on some occasions the allegations were escalated to other external bodies, the appropriate external bodies, and we certainly communicated at all times with the person who brought the allegations to IHMS. When it was finalised, they received a written letter with what the outcome of our investigations were.
On how many of those investigations did you validate the claims about sexual assault?
So sexual assault by an IHMS staff member?
Well, I'm asking sexual assault by anybody involved in the system.
Prior to 2022.
Well, by all means, let's do prior to 2022, but then we'll just assume that I'll then ask you post-2022.
Yeah. So prior to 22, I don't have the number because obviously prior to 2022 we were providing services across 2 different contracts, one in Manus Island and one in Nauru. I haven't come to this inquiry because of the timeframe of this inquiry. I haven't got the number for that prior to 2022, but I can certainly take that on notice.
But there were validations. You validated the fact that people who were meant to be in the care of whichever authorities who had been sent from Australia had been subject to that kind of degrading conduct. You validated that.
With regard to... So the allegations brought to us with regard to IHMS staff members as perpetrators, no, to my knowledge, we never validated that. Inquiries were undertaken, escalated to external bodies, and there was never a finding that there was sexual abuse perpetrated by an IHMS clinician.
But you investigated yourself. IHMS investigated itself. The Australian Ombudsman doesn't have oversight of Nauru. The Australian Federal Police doesn't have oversight of Nauru. I mean, you investigated yourself.
When IHMS conducted an investigation, we conducted a thorough investigation. There are written reports of these. The written reports of the investigation. There were interviews with witnesses. Everything is reported and was also provided to the department. If there was ever an allegation of sexual abuse that required escalation to an external body, then it was escalated to an external.
It's hard to imagine allegations of sexual abuse that don't require escalation to an external body. What are the, did you triage? You said, well, this is an example of an allegation of sexual abuse, and we'll just keep this in-house. We won't escalate this.
No, because the investigations of allegations of sexual abuse by an IHMS staff member, the investigations did not confirm that there was any sexual abuse. We have a chaperone policy in our clinics, and so if there is any, if a clinician is seeing a member of the opposite sex, then there are other people also in attendance for the examination. So we have witnesses who are in the room with patients. So if we're having an investigation, we conduct we get witness reports from everyone who is in attendance as well.
Can I just add as well? All cases are escalated to the Department of Home Affairs as well, so it's not kept internally. As you stated, it is escalated, and it's also, as a patient, they have the right to escalate to police.
To the Nauru Police?
To police, yes.
But we have had so many submissions from people on Nauru that their complaints to police are ignored, their statements are lost, that a complaint to police can often find themselves being assaulted and attacked by the person who they complained about. Is it your evidence sitting there that people on Nauru who have been sent there by Australia have a valid and real expectation that Nauru Police will take their complaints seriously? And if so, can you point to a single case where Nauru Police have prosecuted anyone for a serious offence against someone who's been sent to Nauru?
Yeah, look, I think that's outside my scope of expertise and experience. I think...
well, you're the one who gave the evidence that they can go to the Nauru police. What I'm telling you is all the evidence we have is that the Nauru police do not help, actively don't help, can be witnesses of crime and not even intervene. You volunteered that as a solution. Are you aware of a single instance where it's been a valid solution?
As I said, no, I'm not aware of any cases that, not the valid solution, I'm not aware that there's been a case that's been escalated to police that hasn't been resolved. I'm not aware of, we're working in Nauru, we're working within their system and we're working within their framework, so we are operating in a foreign country.
Indeed. And does the Department of Home Affairs undertake an independent investigation when you advise them about allegations of sexual assault?
That would probably, Senator, be a question to direct to the department.
Well, I'll ask them next, but you refer things up to the Department of Home Affairs. What happens? You have an allegation of sexual assault. You refer it up to the Department of Home Affairs. What do you see coming from that referral to the Australian Government Department? What do you see? If it's nothing, then just say nothing.
No, when we undertake an investigation, we do a comprehensive investigation report that is then passed to the Department of Home Affairs.
And what do you see? What do they do with it? So far as you can observe.
Yes.
Nothing.
Well,
so far as you observe, nothing. Is that right?
Yes, that's a question for the department.
But you give it to them, and then from your observations, nothing.
No, there will be a discussion. Obviously, we meet with the department regularly. So this is if there is an allegation of sexual abuse is a critical incident. So we, there's all sorts of reporting requirements. We're required to undertake a very, very comprehensive investigation.
Which you then give to the Department of Home Affairs, and you said nothing happens.
Well, we would get feedback from the department that they have, that they have read the report and that no further action will be being taken.
Yeah, I understand. We have testimony from a person who's on Nauru seeking asylum who said in a submission this: mentally I'm not well. I've asked for a counselling appointment at the IHMS clinic, but they still have not given me an appointment. I've not counted how many times exactly, but incidents of having things thrown at us like this are quite frequent, up to 3 times a week. How often are you getting reports like that? People having things thrown at them, being assaulted, and how often are they not getting appointments?
So we have a requirement. So for making appointments with IHMS, refugees and asylum seekers can make an appointment in a whole different ways. So generally there's a phone number that they can ring and make an appointment. If they don't want to ring and make an appointment or text and make an appointment, they can email and make an appointment, or through one of their liaison officers. They can request that liaison officer make an appointment for them, or they can come up to the clinic and make an appointment. When we have a request for an appointment, we have a contractual we are contracted to see that person within 7 days of them making that appointment. That is one of our key performance measures. We have a performance management framework with 15 key performance measures we report on every month. So that is key performance measure 11, that we triage a request for a consultation and we see that person at least within 7 days of the request of the appointment.
Well,
at no point have we ever failed that key performance measure. So every person who has asked for an appointment with IHMS has been seen within 7 days. Now, when they are given their appointment time, if they do not attend that appointment for whatever reason, so they may have work, for example, and they've got a job and they can't come to the appointment, if they don't show up for the appointment, they are then given another appointment.
You don't ask them? You don't schedule an appointment around their work?
If something has come up in their life and they can't attend the appointment and they do not attend, they don't appear, there is then a discussion and they're given another appointment. So from that initial request, there are 3 appointments made to see that patient. If after the 3rd time they don't come to the appointment, then they need to make another appointment. but we have absolutely no evidence at all of someone who's requested an appointment not being seen within a maximum of 7 days.
We have multiple submissions from people on Nauru that say they have serious health issues, and what they get from your organisation is at best sleeping pills and Panadol. Have you had these complaints made to you about that lack of adequate care?
No, we haven't had those complaints, and look, as part of our clinical governance, if we do get someone submitting a complaint, we'll investigate and review.
Well,
and
I'll read you
rectify
this
the
submission. There are seriously inadequate medical services in Nauru. I have a serious medical condition and I'm supposed to have a checkup from a specialist every 2 months. I've only received one checkup for my serious medical condition here. For any pain or complex health problems, they only give us one medication, Panadol. That's their solution. You're saying you haven't heard of any of these complaints? Have you looked at any of the submissions that we've had in this inquiry? And I'd invite you to go through the attachments to the ASRC report, which has multiple instances of this, directly contrary to what you're telling us.
Yes, that's correct. And we've looked at those submissions and our site staff can identify who those submissions are from, and they have checked the medical record, and the medical record shows that the people making the submissions have been seen on numerous occasions, and in fact one of them has a psychiatric referral, and that's in the next few weeks. And you know, if the senators on this committee would like to see the records, obviously we have a very, very comprehensive record system, and we can provide records of the appointments, records of the medication.
Feel free to provide that on notice, but to the extent you've tried to match your data against those submissions from the ASRC, feel free to provide that on notice. It's just we have limited time, so we'll go to MTC. You said, I think, sorry, I can't read your surname. Troy?
Troy Ittenson.
Ittenson?
Correct.
Yeah, thanks, Mr. Ittenson. You said that there's a high level of local subcontracts that you have. What's the value of what's the current value of subcontracts you have with Nauruan individuals or corporations?
The annual total value of subcontractors is around $30 million.
How much?
$13 million.
13 million?
30.
Oh, 30 million with Nauruan. Do you have any contracts with the Nauruan government or corporations owned by the Nauruan government?
For the list, I again defer to Mr. Sid Mehta.
Mr. Mehta?
Thank you, Senator. Thank you, Senator. Yes, there are government-owned agencies operating in Nauru that we subcontract to provide various services.
Can you provide a list of those contracts and the contract values and who you contract with that are government or government-owned corporations and the contract values? Can you provide a list of that on notice?
Yes, we take that on notice.
Of course, many of the Nauruan government entities and Nauruan corporations have very close ties to the current president, former president and senior politicians. How many contracts do you have with Nauruan entities where a current or former member of the government is either a shareholder or a director of the company?
As we indicated, we go through a comprehensive due diligence process based on the information that is available to us in Nauru. All subcontracting agencies and their office holders are provided conflict of interest declaration forms. All the subcontractors that we currently engage have declared and completed that conflict of interest form. Based on the evidence and the information that is available, it's very hard to ascertain the actual ownership or part ownership of an organisation in Nauru.
Do you make the effort? Do you have a look
Absolutely.
and see whether or not a shareholder or director is, for example, David Adiang or Lionel Anjima? Do you make the effort? Do you go through the corporate records?
To the extent it's available in Nauru, yes, but a lot of this information, similar to what's available in Australia, like ASIC records, etc., are not available in Nauru.
You could demand it of them when you issue a contract with them. If you're going to hand over $30 million of basically Australian public money, you could demand this of them, but you don't. Is that right?
Well, we get them to declare any conflict of interest with the office bearers. So we do ask them to declare any of their potential conflicts.
So Nauruan entities self-declare, and you rely upon the self-declaration from Nauruan entities. Are you aware of the repeated reports of gross corruption, money going to people who are bikie gang members, money being siphoned off to the president and former president? Are you aware of those allegations when you accept the self-declaration from Nauruan entities?
So, and I'll just go through again the process of providing. We get all the information we can, get the subcontractor to provide that information and declare all the information they have. Then we submit it to the Department of Home Affairs with all the information for their endorsement.
Well, so when you handed up, when you decided to enter into a contract with Chazak Corporation for water delivery services, can you remember the value of that contract? It's quite recent. I think it was in October of last year. Do you remember entering into that contract?
Yes, we do.
Do you know the value of that contract? To assist, was it $761,370 or about that?
Annually, approximately, that sounds about right, Senator.
You know that it's the parent company of LRC Car Rentals, don't you? You would have checked that.
Well, we entered into the contract to provide water delivery services with Chazak, and all the declarations, subcontract, etc., in relation to that organisation was shared for due diligence process with the department.
Yeah, and no doubt you got a signed conflict of interest document from Chazak Corporation Limited that said nothing to see here, all fine. You would have got one of those documents from them?
As part of the process, all the documents required by the departments were completed and shared with them. Conflict of interest was part of that document that was shared with the department.
So when you entered into that contract, as recently as October of last year, did you cross-reference the multiple allegations of corruption and kickbacks, including in AUSTRAC reported documents, that the Adiang and Angiama families had in relation to LRC Car Rentals, for example, that was on the public record? Did you cross-check their conflicts of interest declarations against all that public reporting about the corruption for LRC Car Rentals?
All I would say again, Senator, is that we provided the requirements as per the contract. Again, the contracting and subcontracting arrangements were reviewed by the Richardson Review and were endorsed by the Richardson Review. And we continue to provide the high level of scrutiny that's required by the Department of Home Affairs and their endorsement of those subcontractors.
Well, I will put some more questions on notice, but your parent company, MTC's parent company, you're wholly owned by the NTC entity from the United States, aren't you? You're a wholly owned subsidiary.
Yes.
Yeah. What do you say to the Australian public about the fact that your parent company had to pay Mississippi $5.2 million to settle a bribery case because, and I quote, MTC defrauded the state by engaging in a conspiracy scheme involving bribery, kickbacks, misrepresentations, fraud, concealment, money laundering and other wrongful conduct? What do you say to the Australian public who's signed a $766 million contract with your company when your parent company has been found to engage in that conduct in Mississippi?
I thank you, Senator, for the opportunity to provide a response. In 2014, Mississippi authorities announced an investigation involving former Department of Corrections Commissioner Chris Epps and a consultant, Mr. Cecil McCory. MTC was referred because we operated state facilities and, like many providers, engage employees and local consultants. MTC was not accused of any wrongdoing and had no knowledge of improper conduct. MTC hired Mr. Conroy in 2012 to assist with stakeholder outreach and general advisory services after it opened. A competitive procurement process in which MTC was selected to operate facilities in the state of Mississippi. When bribery allegations became public, we promptly terminated the engagement and cooperated fully with authorities. MTC maintains a zero tolerance of policy of bribery, corruption, and complies with all applicable laws, including MTC and international bribery statutes. Following this situation, MTC thoroughly evaluated its process for hiring consultants and including moved to oversight of consultants to a different department. Our mission is to operate safe, secure facilities and deliver exceptional services to our clients' customers with integrity, and we support rigorous procurement processes and strong oversight and maintain committed to transparency and with our government partners. And I'll add that MTC to this stage still manages facilities for the Department of Corrections in Mississippi.
The poor people of Mississippi. Thanks, Chair.
Thank you very much. I've just got a few questions for the MTC, and then I understand Senator Cox just has a couple of clarifying questions, and I'm conscious of time. In terms of the MTC, since you started managing detention centres for the Australian Government, how many cases have there been of attempted escapes from your facilities, firstly in Australia and secondly offshore? And in how many instances, respectively, have people successfully escaped from those facilities?
In Nauru, there have been 0 attempted escapes. And I'd like to take on notice the number of escapes and attempted escapes in our facilities, given that we have a number of contracts, and I just want to ensure that I get the numbers correct.
Excellent, thank you. I would appreciate that. According to the most recently quoted figures on the public record, the Australian Government has so far managed to remove only 6 people from the NZYQ cohort from our country under the third country reception arrangement with Nauru. That still leaves over 300 of that group here in Australia. Are you able to give me a figure of how many of those people are currently in immigration detention in Australia, including those that are potentially awaiting transfer to Nauru?
No, sorry, Senator, I'm not aware of those figures.
In your centres? So
in my centres, I'm not aware of those figures.
Can you provide that on notice, please? Because I'm assuming that's information you can, the people that are in your custody.
Yes.
Thank you. Is it fair to say, and this might be difficult to answer and it may be something you want to give on notice, but if there are over 300 of those people still here in Australia, has that increased your company's workload and the strain on your staff and contractors?
I'd like to take that on notice, Senator.
Certainly. So it's information you don't have on you? That's
not that exact information as to the different, like, saying what's putting stresses on staff or not. So I'd have to take that on notice to see if there's a direct correlation.
Okay. Sure. Has anyone from the MTC been involved in any discussions with the Department of Home Affairs or the government more broadly about concerns in relation to the issue of increased operational workload for your teams?
All operationals, we maintain high levels of dialogue with both Home Affairs and Australian Border Force. And we continue to discuss operational issues at all levels, both at senior levels and operational levels and centres.
Have you spoken specifically about increased operational workload with them and what that means for your workforce?
Not exactly in operational workload, just different environmental pressures.
Do you want to expand on what those environmental pressures are?
Well, currently, Centre, we're going through a number of operational issues that I'd like to take on notice to provide you rather than giving operational issues openly.
So taking something on notice is different. So are you refusing to answer the question, or are you taking it on notice? They're two different things.
I'm taking it on notice, and I will answer.
Okay. Have any members of the NZYQ cohort escaped at any point in time from your sort of partners or contractors' custody?
I'd take that on notice, Senator, but to my knowledge, no. But I'd like to take that on notice to confirm.
Okay. Is Michael Ancock one of the members of the NZYQ cohort in your custody?
Senator, I have no knowledge of that name, so I'd have to take that on notice.
Okay, thank you. What formal risk assessments and escort protocols had been... that might be it. Might go to Senator Cox.
Thank you very much, Chair. I just wanted to have some follow-up questions with IHMS, if I can, just to get a few details on the record. I missed your opening statement, unfortunately. I stepped away for a moment, but did you tell the committee, or can you tell the committee how many staff in your clinic in Nauru?
Yes, yeah, I can do that. That was in our opening statement. So we have a banded staffing model. So the number of staff that we have both in offices in Australia but also at site in Nauru is dependent upon the band of refugees, the number of refugees and asylum seekers that are in our care in Nauru. So currently we're operating in what's called the active state because there are obviously refugees and asylum seekers under our care. And the band is between 51 and 100 refugees and asylum seekers. So at site in Nauru, for that number of patients, we have 20 staff. Of those 20, 18 are clinicians.
Sorry, can I just stop you there? Senator Cox, we do have all of this on the record from earlier, and I'm just conscious of time. Just to... yes, thank you, because you did go into that in some detail. It's just, thank you.
Yeah, and you did explain the services, right, in your opening statement that you provide in Nauru?
Yes. Quite thorough.
And how they engage with the hospital. Sorry, I'll just run through the questions that I have.
With the hospital, I might
And
pass
if any of those services are shared?
Yeah, so our patients are entitled to go to the Nauru hospital as well, and they're entitled to come to us as well. But we provide a free of charge service. All their medications are free of charge. All our services are free of charge.
Okay. Great. Can you just provide us with, and you may have already done this in your opening statement as well, but a general sort of overview of the IHMS infrastructure in Nauru, like the number of beds, the facilities within the clinic, and sort of any of the team arrangements, or I'm happy for you to take that on notice as well.
Look, I can start. We do have quite a big footprint there. So we have a large primary care clinic with also emergency capabilities. So we do have 2 resuscitation beds, so 2 beds capable of managing a critical patient for up to 72 hours. We do have in that clinic as well 8 what I suppose we call short stay beds. So we do have quite a large clinic footprint there, and we've gone through the staffing as well. We also do have lab services, so point of care testing. Our doctors and nurses can do certain blood tests and certain emergency electrolyte tests, etc. We also have X-ray, so our clinicians can do some diagnosis work with the X-ray, and we will also have imaging, so ultrasound is available to us. If we're to escalate that to a CT scanner, we do have access to the hospital's CT scanner, so we can refer our patients to the hospital, and that's how we work with the hospital in that regard.
That's great. Yeah. Thank you very much for that. Just in relation to mental health services, what is the services that you provide to transferees in Nauru?
Yep. So we look in terms of personnel. So we have a psychiatrist, a consultant psychiatrist in Nauru, full time. So we have a back-to-back psychiatrist that comes in that leads the service from a medical point of view. We have a mental health team leader who's a mental health nurse. We have 3 other mental health nurses as well, and we have the TNT counsellor as well. We do primary care, case management, and we also have the ability to do one-on-one, showing at short-term inpatient care as well with mental health patients. If there are cases that can't be managed on Nauru, we also have the option to escalate that obviously to a centre, and most likely the centre is in Brisbane that we transfer to. So, yeah.
Great. And does IHMS have subcontractors at Nauru?
We don't have any contractually defined subcontractors, but we do have third-party service providers that we would engage for delivery of our care, which essentially would be providing pharmaceutical, consumable support. There's obviously a lot of travel to and fro. If your question is about contractual arrangements with service provision on Nauru, with Nauruan entities, our major relationship is with Igigu, which I'm not quite sure, is it a state-owned entity? It is, yeah.
Is it an acronym or is that the name of it?
It's a name of it. We can give you the spelling if needed, but that's essentially for the provision of vehicle hire.
Okay. How are they managed then? Like, are they through some sort of contract as a third-party service provider? Is that what you explained it?
It is, yes, yes.
And who manages those arrangements?
It's actively managed on location by the health service manager with the support as required from our legal team and our operations crew.
Excellent. Thank you very much for that. Thanks, Chair.
Thank you very much, Senator Cox.
One question on notice, if that's okay.
Certainly.
Unless you have the numbers here. You said that every time a request had been made to send somebody to either Australia or Taiwan for medical health, that's been complied with. How many occasions has someone been sent to Australia for medical assistance and how many occasions to Taiwan?
Since 2022?
Yes.
We may have it.
We do have those numbers.
Yeah, well, I thought you might take it. And we don't have a lot of time, so if you could take that on notice, that would be fine.
Yeah, fantastic. Thank you. And thank you very much for participating and giving evidence today. If there are questions that you have taken on notice, if you could get those answers back to the Secretariat by the 18th of May 2026, we would be very grateful. If you have that detail there that Senator Shoebridge has just requested, you are welcome to provide that via the Secretariat now, if that's easier. But thank you very much again. You are now all released, and we appreciate your time. I will now welcome representatives from the Department of Home Affairs.
Everyone saves time.
Have a deep breath.
Fantastic. Thank you for taking the time to come in and speak with the committee today. Before we begin, I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I get you each to state your full name and the capacity in which you appear today? we want to start it.
Rear Admiral Brett Saunders, the Commander of Joint Agency Task Force Operations Sovereign Borders.
Claire Sharp, Head of Immigration.
Michael Thomas, Deputy Secretary, Immigration Compliance.
Ben Biddington, First Assistant Secretary, Offshore Programs and International Cooperation.
Fantastic. And do you have an opening statement today?
No, we don't, Senator.
Fantastic. We might jump straight into questions. Senator Shoebridge.
Thanks, Chair. Thanks for your attendance today. Is the department involved in the current court case in PNG over $11 million in unpaid accommodation costs to refugees at Lodge 10? Are you involved in that case?
Senator, not to my knowledge.
All right. There are proceedings to join the Australian government to the court case brought by refugees. The PNG government, in a defence, has said that it's the Australian government's responsibility to provide accommodation support and costs for refugees at Lodge 10. Have you been engaging with the PNG government that have been making these claims in the court case, saying it's the Australian government's responsibility? Has there been any response or engagement with PNG?
Senator, we do work closely with the Papua New Guinean government, consistent with the arrangement that we entered into some years ago. I might let Ms Jones talk to the way we engage and if she has the specifics about that case.
Yes, thank you. Nerese Jones, Assistant Secretary, Complex Case Management and Support Programs. We work with the PNG government, specifically the Immigration and Citizenship Services Authority, providing capacity building support for them to resolve the residual former regional processing caseload in PNG. The matter that you ask about, I note was reported in the ABC News, I believe last week. The Australian High Commission has received legal representation from the accommodation provider in relation to outstanding accommodation fees. They do not relate to the Australian government, and that is a matter for the PNG government.
Well, you say there's you have an ongoing relationship with PNG's migration. I assume that would include the Chief Migration Officer and the other officers inside the PNG department?
Yes.
Have you raised with the PNG, your PNG colleagues, the reporting that PNG's then Chief Migration Officer received some $10,000 in kickbacks from Mei Lin, who's currently facing drug smuggling charges in Australia? Has that been part of any of the discussion with PNG?
Not an issue that we've discussed with PNG government.
Well, you don't think it's an issue when there are allegations that senior officials inside the PNG Migration Department are receiving kickbacks from somebody who is travelling to Australia and doing drug runs to Australia? Those sort of corruption concerns, you don't raise them with PNG?
That's not an issue subject to the work that we're doing with PNG.
Well, Moses Maladina, the former Deputy Prime Minister of PNG, received a significant amount of money from offshore resettlement contracts that were with PNG. Are you aware that the company, I think it's Chatswood PNG Humanitarian Program Limited, received money from the Australian government for offshore resettlement? Are you aware of those flows of money?
Did not receive any money from the Australian government.
Okay. Did it receive money that was sourced from the Australian government that went through the PNG government?
That may be the case.
Mm-hmm. You're aware that Maladina ran the PNG humanitarian program with Mei Lin and hired her for a senior role in that Chatswood company with Australian money? Are you aware of that?
Those arrangements were a matter for the PNG government.
Well, even though it impacts on Australia, because Mei Lin is now in court facing criminal charges for drug smuggling into Australia, flying drugs into Australia. It's a matter for the PNG government whether or not the former Deputy Prime Minister contracts with someone like that using Australian money. You say that's a matter for the PNG government? It's Australian money.
Australian government didn't have anything to do with any of those contracts. That was the PNG government that was identifying those contractors and engaging those contractors.
With Australian money. You know, there are nurses out there paying tax, and your department is giving that money to PNG, who's then giving it to a company that has the former Deputy Prime Minister on it and a now prosecuted drug runner on it. I don't think Australian nurses and teachers appreciate you giving our money for those purposes. But you say it's not a matter for, you don't look at it once you hand the money over in a big chunk to PNG, it's just a matter for the PNG, is it?
Senator, I think Ms Jones has answered the question you asked a couple of times. I don't think there's anything further we can add to this.
Well, PNG did a forensic audit into some of these payments, including the payments involving Moses Maladina, the payments going to Chatswood PNG. They've done a forensic audit of where the money that was sourced in Australia has gone to. Have you sought access to PNG's forensic audit? It's Australian money. Have you sought access to PNG's forensic audit?
Point of order, Chair. So the Senator let the officials answer the question instead of constantly interrupting.
Certainly.
I should rule on that.
Just for the record, there was no interruption. So I'll ask again. The PNG government have done a forensic audit, including into payments from money that was sourced from Australia that went to Chatswood PNG, a company associated with the former Deputy Prime Minister of PNG, Moses Maladina, and Mei Lin, who's now in Australia facing drug smuggling charges. The PNG government have done the forensic audit about where the Australian money has gone. Have you sought access to that forensic audit by the PNG government?
Senator, I think we'll need to take this on notice because I don't know the answer to that.
And I have not seen the report.
So we'll take on notice whether we've sought access.
Ms Jones, you haven't seen the report. You're the person who's been responsible for the dealings with the department. You said it at the beginning. That's your job. Have you requested that forensic audit?
I have not.
Why not?
It's a matter for PNG to determine the spending of the money in relation to the humanitarian program.
Even if it's Australian money? Is that right? Even if it's Australian money?
I've answered the question.
Turning to Nauru, will you provide a copy to this committee of the MOU that the Australian government has signed with Nauru, under which $2.5 billion of public money is now going to be provided to Nauru over the coming decades for the NZYQ cohort? Will you provide that MOU?
Senator, we can take that on notice and seek to provide that to the committee.
You've previously refused to provide that MOU when it's been requested by the Senate and when it's been requested by other parliamentary committees. Can you remember why you've refused to provide it?
Senator, I believe the Minister for Home Affairs made a public interest immunity claim, and correct me if I'm wrong, I think it was based on the sensitivity of the arrangement at that point in time. Some of that sensitivity may have fallen away with some ongoing litigation, though. So, as I said, I will take it on notice and seek to provide it to the committee.
Mm-hmm. We heard earlier that IHMS has contracts with a company called Igigu Solutions, and I apologise for my pronunciation, it's E-G-I-G-U. Were you aware of IHMS using Australian money to contract with Igigu Solutions?
Senator, we do, as you've heard in previous estimates hearings and from both IHMS and MTC, have an arrangement whereby we do know about any major subcontracts that are used. So, yes, I believe we did know about that
Mr.
relationship.
Thomas or Mr. Biddington, were you aware of that contract?
Senator, I think the IHMS folk characterised it not as a formal subcontract, but a third-party arrangement.
Sorry, a party arrangement?
A third-party arrangement, I think, was the terminology they used, but I'll see if Mr. Manwaring can confirm that.
Senator Peter Manwaring, Senior Director, Offshore Programs Enabling Branch. Yes, Senator, we were aware that IHMS engaged the Gigu Solutions Corporation as a supplier for vehicle hire.
And did you do due diligence? Did you look at it? Did you approve that?
Senator, the threshold for the IHMS contract in terms of major subcontractors is actually higher than that for the MTC contract. So it's $1 million per financial year. There are no contracts under the IHMS arrangement that meet that threshold.
So if they organise a series of contracts under $1 million, they don't have to. You don't review it. You don't oversight it.
We obviously still review any sort of invoicing arrangements to ensure that they are actually fit for purpose and they meet the relevant PGPA requirements.
What's the value of the Gigu contract?
Senator, I'll need to take that on notice. I don't have that detail here.
Well, you see, Gigu Solutions is a fully state-owned Nauruan corporation, isn't it? And the current minister responsible for it is President Adiang. That's right, isn't it?
Senator, I'm aware that Gigu Solutions Corporation is a state-owned enterprise of the government of Nauru. That's correct.
And the current chair is the president's brother, and a director is David Angjamia, the brother of Lionel, the former president. That's the current makeup of Gigu Solutions, isn't it?
Senator, I don't have that detail with me. I'll need to take it on notice.
All right. So how much Australian government money is going to a corporation that's literally in the pocket of the Nauruan president and his brother and the former administration? How much Australian money is going to that corporation? And did you say you haven't done a due diligence on it? You just let that roll?
Senator, as I stated earlier, the due diligence around, there's a due diligence process primarily around major subcontractors. The threshold for a major subcontractor under the IHMS arrangement is $1 million. So the due diligence process that is talked about in our submission, etc., in relation to IHMS is only required for subcontracts that reach that threshold, and no contracts or arrangements reach that threshold for the IHMS arrangement.
So IHMS could be signing contract after contract after contract with companies that are owned or controlled or benefiting Lionel Angomia, the current president Adiang, could be signing contract after contract, and you don't check. You don't do any due diligence. Australian taxpayers' money just rolling out and you don't do any due diligence. It's a very convenient threshold, isn't it? So you don't have to look. Is that why it was set at $1 million? So there's less corruption, you see?
No, Senator, I don't believe that that's the case.
Well, why is there a different threshold for IHMS than there is for MTC? What's the threshold for MTC?
The threshold for MTC is $50,000 per financial year.
So why $50,000 for MTC, where obviously Australian taxpayers would want to see, particularly in a corruption-prone environment like Richardson points out in Nauru, checks? Why $50,000 for MTC but $1 million for IHMS? Why is that?
Senator, I don't have that detail with me. I'll need to take it on notice.
See, I'm led to the conclusion it's so that you don't see the corruption, so that the money can flow corruptly and you don't even get to have to look at it. Was that why it was done? That why the $1 million threshold was put in place, so you don't see the corruption?
Senator, Mr.
Sorry, Chair. Point of order. I feel like that's an incredible accusation to make towards public officials who are giving evidence here this afternoon. And I'd ask the Senator to withdraw it.
All right, I'll withdraw. I'll move on. Has the department been made aware of corruption allegations relating to David Angomia and David Adiang? Have you been made aware of corruption negotiations involving one or both of those individuals?
Just clarification, so did you say corruption negotiations?
Corruption allegations.
Senator, there's been a range of, obviously, media reporting and other information that you're probably referring to. We are aware of information that's in the public domain about allegations and accusations.
Are you aware of other reports that may have happened internally? Have there been internal concerns raised with you about corruption allegations involving one or either of those two?
Senator, what do you mean by internal?
People within Home Affairs. Have they raised concerns about corruption involving one or other of those two?
Not that I'm aware of, Senator, but I'll take that on notice.
We heard from MTC earlier today that they're providing funding to LRC car rentals. There have been now nearly 5 years of corruption allegations, including involving payments through LRC car rentals. You signed off on the contract with, was it Chazak? The parent company of LRC car rentals. When you signed off on that contract for MTC, did you investigate the allegations of corruption involving LRC car rentals, a wholly owned subsidiary of Chazak?
Just to clarify, Senator, I think MTC Australia gave evidence that they have a subcontract with Chazak, not LRC car rentals.
Correct.
Noting your comments around structure, but I'll...
So Chazak parent company, LRC car rentals, corrupt as all get out. MTC enter into a contract with Chazak. Did you undertake a due diligence about the corruption allegations involving LRC car rentals, a wholly owned subsidiary of Chazak, when you agreed to the $750,000 contract with Chazak?
So, Senator, it might be useful to step through the process by which...
More useful if you just answer my question, given the shortness of time. Did you undertake a corruption investigation? Did you review the corruption allegations involving LRC car rentals when you signed off on the $750,000 contract with Chazak?
The department undertook its due diligence process.
Did that involve investigating the corruption allegations?
It involved looking at conflict of interest declaration and the risk assessment associated with the Chazak.
But we heard from MTC that the conflict of interest declarations are just signed by Nauruan officials and aren't separately checked by MTC. My guess is, if you just looked at the conflict of interest declarations, it'll all be sweet. Did you go behind the conflict of interest? Did you look at the reality? Did you investigate the corruption?
So, Senator, the department does its own due diligence in relation to both the risk assessments and the conflict of interest declarations. So the department undertakes its own independent checking in relation to those matters.
Did you investigate the corruption allegations? Simple question.
Senator, I'd have to go back and look at the specific paperwork in relation to that matter to understand the precise nature of the investigations at the time.
We've had multiple submissions identifying systemic corruption on the ground in Nauru. They've come from across the spectrum. I'll give you one submission that's actually come from somebody who the Australian government has sent to Nauru against their will. Submission 12 from the ASRC, if you want. There's a lot of corruption here. I know this because there are a lot of funds that are sent from Australia to Nauru, but where does the money go? We only get $520 a month. We don't get proper services. The Nauru government is siphoning off that money. They're right, aren't they? Billions and billions of dollars going. And we hear from people who are on the ground in Nauru that they're hungry. They don't get medical services, that there's no transport. Where are the billions going? If not to give someone adequate food, where are the billions going?
Senator, I'm just wondering the best way to answer your question. Would you like us to take
Why
you
are people
through...
hungry on Nauru when the Australian government has paid $15 billion for this project over the last 15 years? Why are the people we send there hungry?
Senator, would you like us to take you through the system for setting the allowance for food?
Explain to me why they're hungry.
Senator, individuals who are transferred to Nauru after they've spent the initial period in the RPC are then moved into community accommodation. While they're in community accommodation, they receive an allowance paid by the Australian government. That is set by reference to looking at the cost of food in Nauru, and we can talk in detail about how we calculate that if that's of use.
Rather than talk in detail about it, if you could provide that on notice, when we hear it's $20 or more for 2 litres of milk, when we hear it's like $15 for a kilo of rice,
Senator,
when these people are being provided $520 a month.
Senator, it is correct that fresh milk is expensive on Nauru. UHT milk is available for $3 to $4 a litre. That's by way of an example. There's a lot of different examples. I think it would be better if we could take you through the detail on how we set it and the reference points we use to set the allowance, which we will do on notice.
I'd invite you to do that on notice because it sounds like it'll be quite time intensive, but I'd invite you to do that on notice, and I'd appreciate you providing that on notice. We've had multiple submissions from people who say they're seeking urgent health care from IHMS. They get given Panadol or they get given sleeping pills. Have any of these complaints found their way to the Department of Home Affairs? Have you investigated these complaints involving IHMS for inadequate care?
Senator, we do have a complaints management system that's there for both people. There's one system that's for people who are in the RPC and another for those who are in community accommodation. And there is a method by which those people can make complaints. They are sifted and go to the appropriate provider. And in all cases, whether it's a complaint relating to relating to MTC or IHMS, or if it's relating to a service provided through the Government of Nauru, the department has officers on the island who meet regularly with all three of those to identify what complaints have been made and understand the actions being taken.
But not to go out and meet with the people that we've sent there, but to meet with these entities on there who are screening the complaints. Is that right?
To my knowledge, the Home Affairs officers don't go and meet with complainants directly.
Why not? Is that because you might hear complaints?
Ms Struggle might be able to provide more detail about that.
Senator Shan Strugnell, Assistant Secretary, Offshore Programs, Operations and Strategy Branch. So we have a team on Nauru, the Nauru support team, which I know you're aware of, Senator. For individuals that are in the community, there's a 3-stage process for complaints. They can, in the first instance, place the complaint in a complaints box at their accommodation site. Alternatively, if it's a serious complaint, such as the ones that you raised earlier, they can put that directly through to the police, or they can use Igugu Solutions Corporation, ESC, which is contracted to the Department of Multicultural Affairs, to advocate on their behalf and support them to file a police report. That information is then escalated in the 3rd stage through to our NST officers, our Nauru support team that I mentioned, representing the department, and then that is raised through our bilateral mechanisms. Through the bilateral mechanisms with the Department of Multicultural Affairs, we seek an understanding of where the complaint is up to and what we can do to support the resolution of that complaint.
Now, Igugu Solutions Corporation is also owned by the Nauruan government.
That's correct, Senator.
Is also controlled by people associated with the President.
That's correct.
Do you understand why people on Nauru who are fearful of retribution may be incredibly anxious about putting their complaints through a company wholly owned by the Nauruan government and controlled by the political players in charge of the Nauru? Do you understand why they might be anxious about going through that process?
I can see your point, Senator, but there are options that they can use for that. that are not just Igugu solutions, as I mentioned.
Ms. Sharp, I was reviewing the number of public interest immunity secrecy claims your government has made over just the last year involving Nauru. A PIA claim over the voluntary return policy, a PIA claim over how much was spent on a assisted voluntary return, PIA claim over which countries people were sent to under voluntary return, PIA claim under quantitative information relating to Nauru and long-term stay visas, one over information on support vessels, one over information on which countries the Department of Home Affairs is negotiating possible resettlement arrangements with, one over the contract outlining details of the services that MTC is required to provide, one over the Memorandum of Understanding on Mutual Cooperation, one over the Memorandum of Understanding between Republic of Nauru in relation to the ongoing presence of people on Nauru, one over any information on the potential for third country reception arrangements with Papua New Guinea, one over the correspondence from the United States regarding its executive order about realigning the United States refugee admissions program, one over the funding arrangements supporting Papua New Guinea's independent management of the residual regional processing caseload, and one over any information on current negotiations between the Government of Nauru and the Australian Government in relation to the resettlement of non-citizens just in the last 12 months. How is it that your department has advised the Minister to put that cloak of secrecy, that entire cloak of secrecy, over all of these critical aspects of the offshore settlement arrangement? Why does the department support this kind of secrecy?
Senator, you're right to point out it's the Minister for Home Affairs who makes the public interest immunity claim.
On your advice.
Each one is supported by the reasons that he considers that it is in the public interest not to disclose that information. Most commonly, and you did raise a number of them, most commonly...
13.
Yeah, therefore, either because they're concerning a very active negotiation with a foreign government where we consider that sharing the information at that stage of the negotiations could, for example, damage the outcome in the negotiations. It could be for operational sensitivity associated with the actual conduct of Operation Sovereign Borders. I would need to go back and re-articulate the reasons that are in each one.
Will you see what it does produce is this cloak of secrecy. And I can tell you what we're getting in this inquiry and what we're increasingly getting through brave whistleblowers is that this cloak of secrecy is covering up an inherently corrupt arrangement where organised cruelty, intentional organised cruelty, can only be done through corrupt arrangements, as we're seeing on Nauru. That's probably the accurate summary of what's happening here, isn't it? A cloak of secrecy, because that's the only way you can prevent the Australian public seeing that intentional organised cruelty involves corruption. That's the truth of it, isn't it?
No, Senator, I don't agree with your characterisation.
Thank you, Senator Shoebridge. I just have a few questions and I will be quick because I am conscious of time. What is the current forecast that you have of the total number of NZYQ cohort members who will ultimately be resettled in Nauru under the third country reception deal? And how does that differ from your original estimates of that number at the time the deal was negotiated and signed?
Senator, we are continuing to work through the cohort to identify individuals suitable for transfer to Nauru under the arrangement. I don't think it's accurate to say we have a forecast. The cohort, it's important to understand the cohort changes as, you know, in terms of the total number of individuals in the cohort changes from almost day to day as visa decisions are made or individuals, for example, complete prison terms. We see the cohort size change. We also see from time to time individuals leave Australia, which removes them from the cohort. And so it's not as though we have a set number that we're targeting. Rather, we have an arrangement that provides an additional removal pathway for some individuals in the cohort.
Okay. How many of that cohort to date have been resettled in Nauru?
8, Senator.
8. And to date, how many people in that cohort have been identified by Australia as a proposed person under the deal have not been accepted by Nauru?
Senator, I can answer that for you. No one has not been accepted. Nauru has deferred their decision on occasion.
How many times have they deferred a decision?
I'd have to take that on notice.
Excellent. If you don't mind, that would be great. Thank you. On the 18th of March this year, the High Court decided that the government's existing ankle monitoring and curfew arrangements in relation to that particular cohort were unlawful. How many members in total of that cohort were directly affected by that judgment on the day that it was made? And what percentage of them are now out in the community and unmonitored beyond basic reporting conditions?
Senator, we prepared for this hearing to focus on regional processing. I don't think we brought briefing material on the EGH19 decision and the operational impact.
I think, Senator, there were approximately 40 people that had electronic monitoring at the time of the judgment.
Okay. Happy for you to provide that on notice. I can take that on notice and confirm. Yeah, that is more than reasonable. And I guess, and this may be one you have to take on notice as well, have you been asked by Minister Burke or any other member of the Albanese government to draft new laws or policies in order to directly respond to the High Court judgment that was made on the 18th of March this year?
Senator, I think we'd need to take it on notice. As I said, we were focused in our preparation on the terms of reference for this inquiry.
No problem. That's fine for you to take that on notice. I think for us this is connected because these are people that are looking to be sent to a third country for processing. So we sort of see that as related, and certainly the closing pages of your submission does talk about that third country reception deal with Nauru, and so that's the basis on which we have drawn those together. For the latest period of which you have figures, roughly what percentage of visa cancellation and deportation cases is a direct removal from Australia frustrated because a country refuses to have one of its nationals returned to it, or there are delays in documentation, or Australia cannot lawfully remove the person due to protection?
Senator, we'll need to take that
on notice. What I might do is I might put the rest that I've got on notice to you. Now, I understand Senator Stewart has some questions.
Yep.
Thank you. Senator
Thank you. And I'll do my best to keep them brief as well. Sorry, let's see if I can get my video on here. Thank you for your time this afternoon. Now, can you provide information on how transferees are managed on arrival to Nauru, and what do they have access to?
Thanks, Senator Ben. On arrival into Nauru, transferees move to the Regional Processing Centre number 1 and received into a facility where effectively the primary concern is health awareness of the individual. They're assessed at that point for health needs. They're provided with translation or interpreter services if that's a requirement. And then over the course of about 3 days, that person will then move into the general accommodation area within the Regional Processing Centre. Within that general accommodation aspect of the centre, the individual has access to a whole range of services, which includes things such as recreation facilities, gym facilities, welfare facilities, counselling facilities. Throughout the centre, there's significant emphasis on meals. So, for example, meals are published for the week. Transferees have a 2-hour window within which to access the dining facility, and there are minimum service standards as relates to food. So, for example, it would be for a breakfast, for example, a continental option plus a hot option, culturally appropriate again, depending on the transferees in the centre at that time, and broadly the full range of sort of welfare and garrison supports that you'd expect.
Thank you. And sorry, just to clarify, that kind of talks to what it looks like when a person moves into the community, and what does management look like?
Sorry, what look like, Senator?
Sorry, you were talking about when they arrive, and then you talked about what it looks like when they move into the community. Is that right?
Oh, sorry, Senator, I'll clarify. Within the centre itself, there are a couple of steps as they're effectively integrated into that centre. My evidence was only in relation to the centre itself, not in relation to the community. Okay. And so those two elements...
Can you now step me through what it looks like when they move into the community and what management looks like?
Yeah, certainly, Senator. So a transferee who moves into the community still maintains a range of underpinning supports to assist them with their placement into the community. So the first of those is the accommodation provided through the Government of Nauru. The second is in relation to the access to medical services. That includes both back to IHMS, which is provided at RPC, but also an option for the individual to seek assistance through the Republic of Nauru Hospital, and then supports more broadly in terms of the processes that they might be engaging with. So, for example, the refugee status determination process, access to telecommunications to do that, access to legal representation, and access to allowances to allow them to live within the community.
And what options are available if a transferee becomes unwell and is not able to be cared for on Nauru?
So, Senator, the underpinning basis for a transferee is IHMS, and IHMS provides the full range of services that IHMS provided evidence about before in terms of the full range of support. So specialists for both, if you like, medical needs and mental needs. The facility itself, which has a number of beds plus the 2 high care beds and the ability to look after a critical patient for up to 72 hours. And in the event that a recommendation is made that an individual can't be managed on Nauru because they have a longer term need, or in some instances perhaps not an urgent need but nonetheless something that can't be managed within the IHMS facility, there are opportunities for review and recommendation that person would then seek medical treatment off Nauru.
Thank you. Now, I've just got a couple of questions about the offshore processing contracts. Can you or someone on the panel talk us through what were some of the key outcomes of the Richardson review in 2023?
Senator, I'll start and hand to my colleagues. That review it had a conclusion that advised government that the government could have confidence in the MTC contract. It did then make 4 recommendations that we have been working through and implementing since Richardson. The 4 recommendations went to how we could strengthen our risk management and integrity processes, recognising that we are operating in a high-risk environment. And I think that's, we've certainly been listening carefully today and to the submissions. We are very cognizant that it is a high-risk environment and that we do need strong oversight controls, which hopefully, as you've heard Ms Stagnall and others talk to with our team on Nauru, we do engage carefully, recognising the environment we're in. In terms of the detail of the recommendations, I might hand to Mr Biddington to take you through those and what we've done in response.
So thanks, Senator. There's many actions taken in response to the review, and I'll give you an example of some of them. We've enhanced the major subcontractor approval processes through implementing things such as a standing operating procedure for the approval of defined major subcontracts. This requires an assessment of the proposed entities, including their employees, officers, agents and advisors, their real, perceived or actual conflicts of interest in their delivery of services. We've developed options for managing Nauru and stakeholders' perceived or real conflict of interest, and put in place effectively clear and unambiguous delegations in response to that. We've enhanced the risk assessment processes for events and triggers. This includes implementing consistent processes for registering, assessing and treating risks identified in the regional processing context. And we're participating in relevant intelligence agency fora where we work with partners across the Commonwealth.
Thank you. So since the Richardson review, would you say that governance arrangements have improved?
Yes, Senator.
And I mean, you talked about this briefly and maybe you want to elaborate on it a bit more. We've heard evidence today with some concerning subcontracting arrangements specifically. I'm keen to understand a bit more about how the department oversees the subcontracting arrangements.
Yes, thanks, Senator. I might start, and Mr Manwaring might be able to provide a stepping through of the detail about how that subcontract process works. But effectively, where there's a need for services to one of our head contractors, our head contractor would engage in that subcontracting arrangement. But where the relevant financial thresholds are met, so for example in the MTC case of $50,000, there's a requirement for review by the department, and Mr Manwaring might assist in terms of how that review process works and the relevant steps that we would undertake.
Thank you, Mr Biddington. A lot of this, I guess the process, we since as a result of the Richardson review, we've actually built a standard operating procedure that deals with the steps that the department takes in relation to the consideration of major subcontracting arrangements. That involves a number of steps. So as Mr Biddington mentioned, the MTC obviously undertake a process where they seek engagement in terms of the relevant subcontractors. They negotiate arrangements. They negotiate a subcontract. However, that subcontract is not executed until it comes to the department, where the department will undertake its own due diligence and risk assessment to ensure that those arrangements are fit for purpose, and I guess continue to meet the need of, in terms of the service delivery that's encountered. The operating procedure has a range of steps in it that goes to decision making in relation to particular matters. So, for example, if the identified subcontract value is above $500,000, it does get pushed up the line, so to speak, in terms of the delegation of the individual who actually decides it. And there are other triggers in that ensure that the decision making in relation to these subcontracting arrangements, which can be sensitive, are actually approved by the relevant area. So there's an MTC process and there's a separate departmental process to consider it before it goes to the relevant delegate for approval.
So it sounds like there's multiple controls put in place to try and make sure that we've got some checks and balances following particularly following the Richardson review. Just got two final questions on third country resettlement arrangements. I'm keen to know what support services someone who is subject to a third country resettlement in Nauru will receive?
So, Senator, a person who is removed to Nauru under the third country resettlement arrangement is granted a 30-year visa from the government of Nauru. In effect, they become a permanent resident, if you like, of Nauru. That means they have rights of entry and exit from Nauru. They have rights to work. They have rights to healthcare, education, as though they're a resident of Nauru. I guess not as though, they are a resident of Nauru. So that's kind of the best way to understand that arrangement. It's not an arrangement for services, but in terms of then access to healthcare, they can access healthcare through the Government of Nauru Hospital. And yeah, they are able to work and do, is my understanding. Have full freedom of movement, obviously, on the island as well.
Yeah, and I think you've answered my second question, really, which is about housing, healthcare, and support that's available to help them integrate into the community, including working.
Yeah, they are provided with free housing as part of that arrangement. So in that sense, they are a little different to an ordinary person who would need to pay for housing. Housing is provided freely.
Thank you very much. Thanks, Chair.
Thank you very much, Senator Stewart. Thank you all for coming in and appearing and giving evidence today. I would ask that for questions that you've taken on notice, that they be provided to the Secretariat by the 18th of May. And with that, that does conclude today's proceedings. Thank you to all other witnesses that have also come in and given evidence to the committee today. Thank you also to Broadcasting and the Secretariat. I declare the hearing adjourned.